can't see your colleagues.
I can't see you, Mr. Jamie.
You can't see me, Judge.
Yes.
No, I can see you.
I can see myself, and I can see Justice Collis. I can't see the other two members of the bench. I don't know how to. Yesterday, I could see all the members of the bench, but I couldn't see myself.
I can see you, although you look like you're in a hologram.
I look like
No. You look fine, Mr. Jamie. You look fine from my end. Do you want us to give you, maybe we can adjourn for 5 minutes, then you can rejoin and see whether that does not assist you.
I can see Justice Motta and you, Justice Collis. I cannot see Justice Malindi, and I can see myself clearly. So it bothers me that, well, you say you can see me clearly. Justice Motta says I look like I'm in a hologram. I don't know what.
With your permission, my sister, I know it's Mr. Jamie on the other side of
I can now see Justice.
Then we can proceed until tea time. If the problem persists, it can be corrected then.
I can now see Justice Malindi as well. Thank you. I'm ready to proceed, Justices. May I do so?
Yes, thank you.
As the court pleases. Justices, I'm going to deal with the HSF COMSA applications. My learned friend and colleague, Advocate Rosenberg SC, will deal with the truckers application, and between the two of us, we will deal, as we decide, tomorrow with the ZIF application. And we obviously have no role to play, it would seem at the moment, in the Amity application, where the minister is represented by a different legal team. I'm going to, if I may just, and I've learned from long experience to never take anything that my learned friend Mr. Butlander offers me as being of assistance at face value, and true to form, that's what he offered this morning. The assistance, which in fact involves, we submit a fundamentally different order that is being sought, and which the implications whereof I certainly have not had an opportunity to consider, especially his suggestion that the period not be extended only for 12 months, as suggested by Mr. Monjapelo, but in effect 12 to 18 months. I just want to pause there. And as I'm indicating to the court, I haven't had a chance to consider the implications of that purported amended relief, which he's indicated he will put into a formal, we don't require notice of amendment. We simply require to know what is the order we're being asked to oppose. And we don't have that in its formulated formulated version yet, so we'll await that, and I would request the court's indulgence for us to respond to that, not on the turn as it were today, because we don't have the document, and I have not had a chance to confer with other members of my team in that regard, or indeed with the Minister's Council in Amity, because it would affect, that sort of relief presumably would affect the department and the minister across the board. So I'd like that opportunity, and with the court's indulgence, I would request that we not be required to respond to that and be allowed to do so in writing in due course once that position is finalized. My immediate observation, though, is that the amended relief that my learned friend now seeks has at least two implications, and I say this subject to what I've just said, Justices, I haven't had a chance properly to consider it, but it has at least two implications immediately come to mind. The first is that it comes, if granted, if the court were to grant 12 to 18 months extension, I ask the court to take note of this fact, and it's a fact, not a legal submission, that an additional 18 months added to the 18 months that have already been granted as an extension of the, or yes, an extension from the original termination date of the ZEP being 31 December 2021 would be 36 months on my maths, which was never very good at school. So 36 months, justices, is 3 years. So you would be effectively being asked to extend the ZEP termination date by 3 years, adding a judicially added 18 months to the 18 months that the minister has already added, albeit in 2 tranches, as we know. That's the first observation I make, factual observation. The second the second observation I make, and that's a legal one, and again, subject to my being allowed to, us being allowed properly to consider the proposed amendment, is that if the argument that we've raised in our heads of argument, that what the court is being asked to do is impermissible because the court is being asked effectively to make a substitution order under the guise of interim relief, if that legal submission was not already sound, which we submitted is, then the extension of 3 years, and you'll recall the argument, one of the arguments made yesterday by Mr. Budlander was that, well, why did the minister not, his argument was the Director General recommended to the minister that there be a 3-year extension, but the minister opted for a 1-year extension. And he sought to make something of that, whether on the basis of irrationality or otherwise. The fact of the matter is, if you were to grant the 12 to 18 months, you effectively, or rather, ZEP holders would effectively get a 3-year or 36 months, 3-year extension. And we submit that makes it very clear that the court would be granting a substitution order of its choice, as opposed to the order, or not the order, but the extension that the minister granted. And we submit for a variety of reasons, which we'll address in the note that I've alluded to, that would be impermissible and trench on the separation of powers principle. That being said, justices, can I proceed on the basis that we'll be allowed to address Mr. Budlander's last submission in that manner?
Yes, I think once you've received it, you've indicated you haven't received it as yet.
No.
So once you've received it, once you've received it, you prepare your written note, and then you'll upload it onto case lines.
As soon as possible after this hearing.
Yes. Thank you, Mr. Jamie.
As the court pleases. May I then proceed to my principal submissions?
Yeah.
We've filed comprehensive heads of argument. I don't intend repeating them. We stand by what we've said in the heads. I have limited time today because we still have to hear Mr. Rosenberg in respect to the truckers application, and then we need to hear 3 replies. So I'm going to try to concentrate my submissions to be of maximum assistance and help to the court. And I'm going to, in so doing, I'm going to concentrate, justices, on a proper understanding and analysis of the decision that the minister took. And that is crucial in our submission because a lot of the conflation and confusion in this case, and a lot of the submissions proceed from the incorrect premise. And that incorrect premise is that in taking his decision in September of 2021, rights. That's a central premise of the applicant's case, applicant's plural case, that the minister took away rights. And then proceeding from that premise, one gets into the usual legal analyses about, well, if you're going to take away rights, you must give notice that you intend doing so. You must give a fair opportunity to be heard from the persons whose rights are going to be taken away. And you must consider their representations, and all of that must happen before you take the decision. Now, we have no quibble with any one of those principles. They all are fairly basic principles. It would be silly for us to say they're not legal principles. The question is, are they the applicable legal principles in the context of this case? And we say they are not. Because the elephant in the room, which our learned friends for the applicants ignore entirely, is what the decision was that the minister took in September and what the implications of that decision were. And we submit that incontrovertibly on the facts, the minister's decision of September 2021 did not take away rights. It in fact conferred rights. And I'm going to take you to the detail which supports that submission, but what I'm attempting to do at the moment is to give a court an overview of the argument. And if I may just interpose, I know the court raised yesterday, I think with Mr. Majapelo, that his argument, he wasn't arguing on the heads, as it were, that he was developing an argument. I plead guilty to the same offense. I'm not following my heads. I'm responding to the arguments we've heard, and I'm developing an argument, and we will try our best if the court so wants. The court's been deluged with paper. I don't want to add to that burden, but if the court would like, I will endeavor to put this argument, as Mr. Budlander did, in written form. But I don't want to do that unnecessarily, so I'll leave that to the court if you'd like me to do so. Yeah. But the argument that I'm now advancing is an argument which you won't find in the same order in the heads, although most of the points that we raise are to be found in our heads or in our answering affidavits. All right.
No, that's fine. You may proceed whichever way you prefer, Mr. Jamie.
As the court pleases. Incontrovertibly, Justices, we say, and we'll take you to the detail of that supports that submission. The decision of September 2021 conferred rights, did not take away rights, it conferred rights. And when that decision was taken, and the first notification of that is the notice in the Star and other newspapers of 5 January, and I'm going to take you to that, it made it clear what that decision was. And it made it clear that, and then the Directive 1 in particular, gave effect. And it references Directive 1, and Directive 1 gives effect to the decision. And Directive 1 makes it clear, Justices, that rights are being conferred which would not otherwise have existed beyond 31 December. And that the right that's being conferred, as part and parcel of the Minister's decision of September 2021, was the right that the permits would be, the permits, not the blanket exemption regime, but the individual permits of Zimbabwean, of ZEP holders, would continue to be valid, notwithstanding the conditions under which the ZEP was granted in 2017. Those permits would continue to be valid for 12 months. And then later on in 2022, I think September 2022, Directive 2, September 2022, Directive 2 was issued, which extended that validity to June of this year, 30 June of this year. So our first principal submission, Justices, is that the decision, properly understood, in September 2021 did not take away rights, it conferred rights. Our second principal submission is that this case concerns, now I'm fully aware, and I've probably been guilty of it too, but the courts would be well aware that government, when it finds itself in litigation, quite often counsel for government refers to separation of powers. And it has been criticized in the past for being an attempt to just evade judicial scrutiny. Now, I am going to refer to separation of powers, but not for that purpose, to evade judicial scrutiny. We welcome judicial scrutiny. And we submit that what the government has done in this matter passes muster on the proper and appropriate degree of judicial scrutiny once the decision is properly understood. And I don't try, and we don't try to evade that scrutiny. But it's vitally important that the court appreciate that you would seldom, if ever, Justices, I say without hyperbole, come across a case that is more worthy of respect for the separation of powers. And that is because this case concerns a policy, heavily policy-laden, overtly political decision by government. First by the minister, but then the minister sought the support of cabinet, and cabinet gave that support in November of 2021. Then it became the decision of government, the South African government. And what the South African government decided, justices, in 2021, was that it would no longer have a blanket exemption policy for Zimbabwean citizens who were ZEP holders as a category of persons who would be exempt from compliance, as every other foreigner is in this country, to compliance with the provisions of the Immigration Act. That was a policy decision. And properly understood, it's not a legal decision. And it's crucial that the court understand and appreciate that. Now, that is an aspect of the matter. It's a crucial, fundamental aspect, which our learned friends understandably entirely do not address. It's nothing new. We've said this in our papers and in our heads. It's a policy decision. Now, let me just pause there for a moment, because this is important. And if I go on in that regard too long, then you will rein me in. But it's vitally important that the court appreciate this. And we're going to take you to where those policy considerations are enunciated in the papers, which motivates the government's position. But I'm addressing separation of powers. Now, government, as a general proposition throughout the world, can and must adopt policies. I'm sorry, there's an echo, justices. Am I still audible, and can the court hear me clearly? Thank you.
Yes, we can hear you clearly, but there seems to be people still being admitted. Tipuo, can you control that, please? Because we're well into the proceedings now. We cannot now still admit people.
Okay, Judge Collins, should I admit them or reject the application?
Admit them when they during the tea adjournment now, because it does actually affect the sound that are coming through.
Okay, okay, Judge Collins.
As the court pleases, justices. Justice Collins, sorry. So governments throughout the world can and must adopt policy. Government would not be incoherent without policy. But there's a fundamental distinction between the adoption of policies on the part of government and its implementation. Implementation almost always will have to take place within the legal framework in terms of laws that government has, or it will have to enact new laws to give effect to its policy. But non-constant, the adoption of the policy is constrained by legislation. And in this regard, and as I say, these submissions don't follow the heads. So to the extent we refer to authority that's not in the heads, we will obviously give the court a note in due course. But can I just remind or take the court, as it were, to a fairly fundamental or fairly basic proposition, which you find in the SAFU judgment of the Constitutional Court, but it's also the Constitutional Court reaffirmed it in the Edu College case. The quote appears at Hoekster Volume 6, Hoekster 3rd edition, at page 239, where the court says the following: policy may be formulated by the executive outside of a legislative framework. For example, the executive may determine a policy on road and rail transportation or on tertiary education. The formulation of such policy involves a political decision and will generally not constitute administrative action. However, policy may also be formulated in a narrower sense, where a member of the executive is implementing legislation. The formulation of policy and the exercise of such powers may often constitute administrative action. Now that, justices, is a fundamental proposition which the court must bear in mind, because we submit that the government's adoption back in 2008, 2009 of a policy that it would exempt Zimbabweans from the provisions of the Immigration Act, which all other foreigners are subject to, was an overtly political, policy-laden decision. Each of the iterations, and I'm going to get to our analysis of the facts, but each of the iterations of that exemption regime was motivated by the same considerations. Not legal requirements, but policy decisions. We as a sovereign state decided that we would exempt, the government decided, to exempt a category of foreigners, Zimbabweans in particular, from the provisions which otherwise would have applied to them. Each of those iterations of the exemption regime, there were 3 of them, came to an end. They were each time limited. They were temporarily limited. The first one for 5.5 years, on my calculation, the DZP. The second for, I think it was 3 years, the ZSP, and the last, the ZEP, for 4 years, from 2017 to 2021. And this is another crucial fact, which I'm going to come to when I deal with the facts. But just to note it, Judge, these were 3 distinct regimes, each of which had a time limit, and each of which came to an end at the end of its time limit. There was no additional decision on the part of the minister or anyone else to bring those regimes to an end. They came to an end when they were intended to come to an end, at the end of their period. The fact that the government in the first 2 cases, at the end of those 2 regimes, the DZP and the ZSP, decided to have, well, at the end of each one, the government on 2 occasions decided to have a new regime, doesn't change the fact that the government didn't decide to end the previous regime. The previous regime came to an end when it was supposed to, and the government then decided to have a new regime. Namely, after the DZP, they had the ZSP, and after the ZSP, they had the ZEP. They enacted or not enacted.
Just to clarify, so these first 2 came to an end through effluxion of time.
Justice, I've now lost.
Mr. Jamie, are you still there?
I am, Justice. I'm just trying to get my. Sorry, Justice, can you see? God.
Yes, I can see you and I can still hear you.
I'm sorry, for some reason my feed has just gone off. But can you see me and hear me, Justice?
Yes, I can. I just wanted to get clarification. So the first 2, the DZP and the ZSP, you say those 2 came to an end through effluxion of time.
I do.
All right. And then the ZEP?
The ZEP came to an end with the effluxion of time on the 31st of December 2021.
2021 also. All right.
But crucially, sorry, Justice, I'm just trying to. This is what happened before. Justice, can I just sorry, can you see me and hear me, Justices?
Yes, I can. Thank you.
What's going on? Sorry, can you see me and hear me, Justices?
Yes, we can. Thank you.
I'm terribly sorry about that. I'm now using my one of my colleagues' Advocate Adhikari's device because mine has just acted up.
That's fine.
I'm going to deal with.
Switch off your previous device because there's an echo now.
Oh, well. Is that in order, Justice?
I think so. Yes. Thank you.
Makes...
You may proceed.
So, Justices, we will deal with the detail. It's set out in our heads, and it's in, I think, common cause that is what happened. Each of these regimes came to an end. But the point that we make is that the decision to have each of these regimes in place. And the decision to have a new dispensation of each of them ended. Each of those was a policy decision. There was no legal obligation, legal, and I stress the word legal. There was no legal obligation for the government to introduce any of these regimes. There might have been a moral reason. There might have been a political reason. There might have been any number socioeconomic reasons, etc. And clearly there were such reasons as to their introduction, but none constat that there was a legal obligation. Now, to fully understand that submission, I would like to take the court back to 2008, 2009. It's common cause, it's on the papers, that what led to the very first dispensation, the DZP, was an economic and political meltdown in Zimbabwe, our neighboring country. There can be no dispute about that. There was an economic meltdown. It led in 2008 to approximately 200,000 Zimbabweans crossing our borders, illegally, largely. And the following year, a further number. And it's referred to in the founding affidavit of HSF, common cause. It overwhelmed our asylum system because these people were seeking asylum. But even so, justices, there was no legal obligation for the South African government to react in the way that it did. It could have said, as other governments have done in many other countries, no, we're turning our face against these economic and political migrants, people seeking asylum, people seeking refuge and succor in our country. We're turning our face against them. We are going to build a wall to keep them out. We are going to imprison, we're going to detain them, lock them up, force them to return, deploy the army on our borders, as some other countries have done, who often seek to give us advice on how we should act internationally. But all of those only go to the point that I'm making, Justice, that those were, or rather that challenge that the South African government faced in 2008, 2009 was a political, socio-economic challenge. And it reacted in that way. Now, before I go to the important distinction, can I just make this point? South Africa and the world has been faced since 2008, 2009 with a litany of other disasters, challenges, etc. I think it was after 2008, 2009, there was a horrific civil war in what eventually became South Sudan, in Sudan. That led to hundreds of thousands, if not millions of refugees and people displaced, internally displaced and otherwise. There has been an ongoing situation of famine and warfare instability in Somalia and Ethiopia. There have been floods in Mozambique. There have been all sorts of disasters, both man-made and natural, on our own continent. South Africa, and in fact, there's reference, I think, in the papers to a similar regime to this being extended on some other basis to Angolans as a category. The point I want to make about the extension of regimes such as this is the decision to react to them in a manner which invokes the provisions of the Immigration Act, and particularly the exemption provisions thereof, is a political decision. It is not a legal decision. It's to be distinguished from the legal decisions, which is how you implement the political decision to react by granting an exemption regime. And this distinction is absolutely crucial to the case, because we submit, properly construed, our learned friends, the applicants, understandably, because that is what they want to do. They want to look after the interests of Zimbabweans as they conceive it. So they attack, without doing so overtly, they are actually attacking the political decision, not the implementation decision. And they do so prematurely and without the facts. And the court doesn't have the facts to consider an attack on the implementation for a number of reasons, which I'm going to address. But one of them is, of course, the implementation is still ongoing. The implementation of the minister's decision of September 2021 only comes to an end on the facts that we have at the moment on 30 June. And we're arguing this case in April. It hasn't yet come to an end, the implementation. And the court has very little, if any, information on whether the implementation has occurred in terms of the required administrative law principles, the provisions of the Immigration Act, and so forth. So that's an inchoate attack on the implementation. Their actual attack is focused on the anterior political decision to have or not to have an exemption regime. And we say that is immune, largely subject to one caveat I'm going to add, is immune to judicial scrutiny for very good reason. For the reasons set out by the Constitutional Court, inter alia, in the authorities in our heads of argument, paragraphs 44 and 46, which I'll take you to. And it's in that context that we raise separation of powers. So just as justices, as horrendous as the situation in Zimbabwe was in 2008, 2009, no one could have come to court and said to a South African court, we want you, judges, to order the South African government to extend a Section 31(2)(b) exemption to Zimbabweans as a category, because we say the situation in Zimbabwe is so dire that it requires government to react in that way. It requires government to protect Zimbabweans by granting an exemption. No one could have done that because it's not a legally cognizable claim. It would fly straight in the face of the separation of powers, but more importantly, there's no legal basis for it. There is no legal basis for it. And in the same way, justices, no one could have brought a claim to court to say, well, you've done it now for the Zimbabweans. Now we say the South Sudanese should have the same protection. So judge ordered the South African government to extend a 31(2)(b) regime to South Sudanese or Mozambicans. In the same way, moving away from these sort of regimes to other aspects of the international or things that may affect South Africa internationally and otherwise. South African government, and sorry, before I go there, and those decisions to have an exemption regime in the case of one category of persons, because the government decides that that is a appropriate policy position to adopt for a variety of reasons, very, very polycentric, policy-laden reasons, political reasons. It's simply something that a court doesn't have the power, firstly, but also the tools to scrutinize and to assess. And it's not the place of the court to do so. The court can't say, and has no power, constitutional power, to say whether it was a good idea or a bad idea to have an exemption regime for Zimbabweans and not one for South Sudanese. In the same way, the court can't say that the South African government, and we accept that those might be controversial decisions, to have it for one group and not another. And how do you assess the degree of desperation of the different groups? And who gets to decide that? Our submission is it's not a court of law. It's a political, policy-laden decision which precedes any consideration of the provisions of the law, which in this case is the Immigration Act. And it's absolutely vital that the court bear that distinction in mind. In the same way...
So let me just understand it. So what you're saying is, unless there's a change in this political policy that was taken by the government, when it comes to implementation, the court can't dictate that.
Justice Collins, what I'm saying is that the policy decision-making is largely, not entirely, because we accept on the basis of feature as a fundamental proposition that all exercise of public power is subject to the Constitution, obviously, and then to legality and rationality. So those basic principles we accept. The government couldn't do something entirely irrational. And one can think of examples. It couldn't do something entirely antithetical to our Constitution, such as For instance, had it allowed a Zimbabwean exemption regime, but not for members of the LGBTQ group, that would clearly never pass constitutional muster, because it would be entirely irrational, discriminatory, etc. So there are obvious constraints to government's ability to adopt policy, even policy.
Particular policy, yes, okay.
But when it adopts a policy which is not obviously irrational, and no one says this policy was irrational, inherent in the ability to adopt a policy is to put an end to the policy. And this is the essential thing that the applicants don't grapple with. They don't grapple with the fact, and they don't accept the fact. And they don't accept the fact that just as government was free to adopt a policy position on extending the protections of Section 31(2)(b), the protection of Section 31(2)(b) to Zimbabweans as a group because of the conditions, the particular conditions that prevailed in Zimbabwe in 2008, 2009, the government is free in 2021, to say that is no longer going to be our position as a policy. We as the government of South Africa, a sovereign country, will no longer follow that policy. We're going to follow a different policy. Now, I pause here because this is fundamental to the case. That is a separation of powers issue. And we say that is not subject to the type of scrutiny that our learned friends for the applicants want to subject that policy decision to. In fact, they entirely conflate, not conflate, they ignore the distinction between the adoption of a policy outside the framework of legislation, as we refer to in SAFU, and the implementation of that policy. We've got no quibble that the implementation of the policy is subject to judicial scrutiny.
Can I just find out if I'm permitted? So you actually stating that there's two issues at stake here. The first one is the policy, which is not subject to Baja. It's subject to the principle of legality. And then you're talking about the implementation, which you say can only happen following the end of the regime, which is the 30th of June 2023. And that would be open to attack on Baja. But you're saying that is inchoate. It's not yet permissible at this stage to talk about that. Am I following you properly?
I'm sorry, Justice. I don't think I made myself clear. I'm not Snow, and with respect, that doesn't correctly characterize the argument. I'm not saying that the decision hasn't been implemented. It has been implemented ever since the decision was announced at the end, well, the beginning it was first announced on the 5th of January, 2022. And since then, it has been implemented. And we'll take you to the report or the press statement in relation to Directive 2, where precisely because of inter alia, a limited uptake of the extension and the opportunity to make representations, the Departmental Advisory Committee recommended to the Minister that there be a further extension, and that led to Directive 2, a further 6-month extension. So we're not saying, Justice Morta, that the decision hasn't been implemented. What we're saying is that an attack on the implementation is inchoate and has not been brought. The case that you have before you and that we are defending is not a case of flawed or unlawful or unconstitutional implementation of the decision. That is inchoate because that's ongoing, and I think our learned friends realize that. Now, my learned friend, Mr. Budlander, yesterday alluded to the fact, well, they asked for documents in terms of Rule 35, inter alia representations and the other documents, and they were refused. Well, sorry, the representations were given, albeit redacted, to protect the identity of the individual, because you'll recall, Justices, there were 4,000 applications pursuant to government's invitation. There were 4,000 applications, or sorry, there were 4,000 representations and 6,000 applications for waiver. And government says in its answering affidavits and our heads that those decisions are being processed. But how they are being processed and what the outcome is not before the court. So any attack on the implementation of government's decision of September 2021 is inchoate, both because the period hasn't expired for that process to run its course. And in fact, it may well be extended further because, as we've said, the cut-off date of 30 June 2023 is not immutable. But for purpose of this argument, I'm prepared to accept that it is. That's the final date, 30 June 2023, because we have no information. There's been no extension beyond that. So I'm prepared to accept that the final cut-off date for these representations and their processing is 30 June 2023. If anyone is unhappy with the way the individual, those 10,000, or in fact, there's probably more, because the 10,000 number comes from data or affidavits that were filed back in September last year. So if there, however many applications there have been representations, they will be, and they are being considered by government. That's on the papers. They're being considered by the department. And any such challenges in COVID, because that information is not before the court, that's not a challenge that we're facing. But my submission is that the anterior decision to adopt the policy position, which is that there will not be a blanket extension or exemption regime in place after 31 December 2021, that is the decision that they've challenged. And that decision is not subject to the sort of challenge that they've launched, which is a PAJA challenge.
Yes, but you've already conceded, and I think you're correct in saying even that policy-laden decision is still subject to Section 1C, scrutiny of the Constitution. It still must be rational. Procedural rationality still needs to be followed. It still needs to make sense.
Sorry, Section 1C, just
1C of the Constitution, which talks about the rule of law.
Yes, no,
from where you glean the principle of legality.
Yes, no, we have absolutely no issue with that. I'm going to
yes. Now, that's the nub of the issue, basically, to look at the rationality behind the decision by the minister to not proceed with the 31(2)(b).
I'm happy. We intend addressing that. We will address it. But before we address that, I just want to, these are sort of introductory comments. I know they are taking some time, but there's another. So I fully intend to address that, but can I make this submission before I do so? I've referred to the elephant in the room being separation of powers, but there's a second elephant in the room. And again, it's vitally important to consider that and to factor that in before you conduct the rationality analysis, which we accept is at the heart of the case, Justice Morta. A rationality analysis is at the heart of the case, and we're very happy. In fact, that's what my argument has been prepared to make submissions on. But before we get there, the court must appreciate this fact, which is part of the factual matrix, and that is, my learned friend, Mr. Butler, alluded to it yesterday. He said it would have been an interesting debate had the government done nothing before 31 December. It had just left the ZEP to expire as it was due to expire. So had the government done nothing, and let's just consider that proposition for a moment. Had the government done nothing, had it simply allowed the ZEP to run down and expire, what would the position then have been? We clearly wouldn't have been in court with this case, because there would have been no decision of government to challenge. Presumably, we would have been in court with the decision, or sorry, we would have been in court with the case challenging government's failure to do anything on the basis that that was irrational. And there may well have been a basis for bringing such a case, saying, we're not telling you what to do, but you can't do nothing. You must make your position clear, because you've given rights to these people for, as the applicants argue, for an extended period, and you can't suddenly allow the regime to end not abruptly, because they were given at least 5 years notification that the regime was going to end from 2017, but you can't simply allow it to run to an end and then on the 1st of January 2022 begin deporting people or regarding them as being undocumented, etc. And there may well, I don't want to argue a case that hasn't been brought, but there may well have been a basis for saying that. So we submit, properly understood, but it's very important to appreciate that had the government done nothing, and secondly, despite the government doing something, the terms of the ZEP were never changed. The ZEP came to an end on 31 December 2021. That is important, very important for this case. Now, what did government do in light of that fact that the ZEP was coming to an end? As always promised, as clear from its terms, and as understood by everyone involved, the ZEP was coming to an end. What does government do? Government makes its position clear. It's now adopted a policy position that we do not consider it appropriate any longer to have a blanket exemption for Zimbabweans as a category of foreigners. We are not going to, on a blanket basis, exempt Zimbabweans from having to comply with the provisions of the Act as everyone else does. So that's government's policy decision. We don't attempt to hide that or make excuses for it. We submit that that is it's within the realm of policy choices that is open to government to make. And we say a court has no place to intrude into that and say, well, we don't believe that that's a good policy decision or a fair policy decision, and thus we are going to scrutinize it for rationality. With respect, it's not subject to scrutiny for, as it were, substantive rationality. The decision, the policy decision. If you get, so to just get back to what government decided not only to make it clear, so there would be no confusion, no uncertainty as to what its position was. It said, we are not going to have this blanket exemption any longer. But then it said something else, and this is clear from its decision at FA8. It said, we appreciate this is going to be disruptive to the persons who thus far have had rights under the ZEP. For that reason, we're going to do two things. The first thing that we do is we are now telling you in clear terms that this exemption regime will not continue. But the second thing we are going to do is to allow you 12 months in order to apply for other visas as provided for in the Act, because you're no longer going to have the exemption. So that's the first thing that we are going to allow one to do, or allow you to do. We're giving you 12 months to regularize your position, if you so wish, and are able to apply for some other visa. The second thing we're going to do is allow you the same period, 12 months, to make any representations that you wish to make on an individual basis as to why the non-extension of the exemption should not apply to you, or why the 12-month period that has been afforded to make such representations is insufficient. So that is what government decided. We make our position clear. The blanket exemption comes to an end. And in addition, you're given 12 months to either regularize your position or to make representations. And we submit that taken together, and it's one decision, it's a composite decision. Taken together, justices, that was an entirely rational decision. The reasons that underpin the decision are to be found in various documents, in particular the submission to the Minister by the Director General, FA 8, but then also in the statement in the public notice to Zimbabwean nationals on 5 January, which is FA 13 to the founding affidavit. And that is the notice which appeared in the Star and other newspapers. And then the reasons also be found in the press statement of 7 January, which is FA 15 to HSF's founding affidavit. To the extent necessary, I'll take you to those reasons. But we submit those reasons just on a reading of them are rational reasons. They are reasons that support the decision. And to the extent that you are going to have judicial scrutiny, justice, of the decision, this composite decision that we talk about, the reasons are there. And those reasons support the position, the policy position that government adopts. And to the extent that the court wants to scrutinize that decision, the decision to make its position clear that there would be no blanket extension any further, but that there would be individual consideration of individual circumstances. We submit the reasons for that are set out. They're rational reasons. And the relevant or required connection between government's purpose, which is to bring an end to the exemption regime on a blanket basis, but nonetheless to respect its constitutional obligations, the constitutional rights of affected persons, and the requirements of procedural rationality. In other words, to give them the opportunity to make representations as to why this decision should not affect them individually, that opportunity is given. So there is a clear connection between the purpose, which is a legitimate government purpose, we submit. And that purpose is to no longer, I emphasize, to no longer have a blanket regime, exemption regime in place. There's a connection, clear connection, when you look at what government did between that purpose and the means selected by government, and this goes to rationality, which you asked me about, Justice Morta. The means selected to give effect to that purpose, and that is the essential. I'm going to take it to the authority. That is the requirement of rationality, that there is a rational connection between means and purpose. And the means selected here is, one, we make it clear in September 2021, as we must. It would have been irresponsible for government to allow the clock to run down to December and do nothing. So government, quite correctly, and we submit responsibly, in concordance with its constitutional obligations, it says, we've taken this policy decision that the blanket exemption must come to an end. It's the appropriate time for that to happen. I'm going to address separately in due course the arguments about conditions in Zimbabwe, etc., but that's a separate issue. But for the moment, just to deal, because I fully agree with great respect, Justice Morta, this is the nub of the case. And we submit, our learned friends never address this and the complexities of this, of what they're asking the court to do. And that's why I'm focusing on this in response to your question. The purpose of government is to bring an end, lawfully and constitutionally, we submit, to a discretionary regime which it put in place without any legal obligation to do so, and which it's entitled to put an end to without the degree of scrutiny and without complying with PAJA, as I'm going to demonstrate to you, is the correct approach. So it puts an end to that regime, and in so doing, or in doing so, once you accept that's a legitimate purpose, government selects a means of doing so, which is this composite decision of September, which makes it clear what the position is, and also affords persons a period of 12 months, affected persons, a period of 12 months to either get their affairs in order or to indicate why their particular circumstances are such that the decision shouldn't apply to them, and or why 12 months is not enough for them either to make representations or resolve their personal positions. And we submit that as eminently not only rational, but reasonable. Now, the court's aware of the distinction between reasonableness and rationality. Reasonableness is a standard that comes into play under PAJA. Rationality is obviously relevant under PAJA as well, but rationality is the standard under legality review. And we submit, at best, the high water mark that this decision is subject to is legality review, legality scrutiny, and thus rationality as a standard. And we submit that taking the decision in that way, saying that we are going to make government's position clear so no one can be left in any doubt as to what it is, that is constitutionally required, and that government does. And then it says, in addition, we're making it very clear that this is not final in respect of it. What is final? Let me not be accused of not being clear about it. What is final, and we have no quibble with that, is that there will no longer be a blanket regime for 178,000 people. That is final. Non-constat that none of the 178,000 can apply for further permissions to remain in the country, in particular to have the provisions, various provisions, certain provisions of the Act waived in their regard, and 6,000 of the affected persons apply precisely for that, to have provisions of the Act waived so they may remain lawfully in the country. Now, justices perhaps, and then we know that the 12-month period is then extended in September last year for a further 6 months, and that is to June. And perhaps it is perhaps it's apposite to begin with the motivation, or rather the press statement, which accompanied Directive 2, which is the 6-month extension. Perhaps it's appropriate to begin there with the factual analysis, which I think, having made those introductory remarks, I would like to go on to. Could I ask the court, or it's to be found, justices, at case lines 10-371. And I'm sorry that I don't have the ability to direct the court members to, I don't know whether any of my 10-371, I don't know how that's done on case lines, justices. I don't know whether the court.
So it's 010.
No, not 0. Oh, sorry, 010. That's correct.
It is 0, yeah.
010
371.
-371.
Yeah.
It's press statement Zimbabwe nationals granted exemption in terms of, the court has it.
Yes.
That document's a press statement which accompanied the issuing of Directive 2. And I'd like to take the court to the heading Progress Report and paragraph 2 thereof. In fact, I should take the court to paragraph 1. Now, I make this submission for at least 2 reasons. The first reason is to indicate to the court, in substantiation of my submission, that the implementation of the September 20 21 decision is inchoate. Both inchoate in terms of time, it hasn't expired yet because it's been extended to 30 June, but it's also inchoate in terms of the court assessing a challenge to it because those details are not before the court. So on those two bases, we submit that this is relevant. Sorry, that's the first reason, the inchoate nature of the implementation process. But the second reason for making this submission and drawing the court's attention to this at this point is to refute a theme that seems to run through our learned friends' case, their heads of argument and their papers, and that is that they never quite elevated quite to saying that the minister is lying and the DG is lying when they say that they will consider these applications that they have elicited or solicited in inter alia, the document I referred to earlier, FA 13, where, as you will recall, representations and or applications were invited. Now, the suggestion is made in our learned friends' heads and oral argument, I think, that, well, if not a sham, this is simply the minister has closed his mind to any such representations. It's an accepted fact. He said in the letter to Scalabrini, which I'm going to address, to demonstrate that the submission based on that is incorrect factually. But inter alia, for that reason, it said, well, all of this is not to be taken at face value when the minister says he will consider and is considering because he's already announced that it's final. Well, that conflates two different points. It conflates government saying the decision to terminate the blanket exemption is final. Yes, that is correct. We don't try to get away from that. That decision is final. There won't be a blanket exemption any further. And we say that's a policy decision, which is subject to a very, very, if at all, is subject to very, very limited judicial scrutiny on the basis we've indicated. But while that decision is final, no final decision has been made in respect of individual applications which have been invited. And I reiterate, those applications and their outcomes and where they are in the process is not before the court. So the court cannot assess that or those applications and assess whether they've been lawfully, reasonably dealt with. And again, that's not a challenge before the courts in this case. And those decisions are not final. And the conflation on our learned friends' part is they conflate the finality of the decision vis-a-vis a blanket exemption from the non-finality and the open-mindedness of the minister and government in respect of the individual applications which have been solicited or invited. And in fact, can I just make this point? In fact, the only basis upon which the court could find, or rather, let me rephrase this way, the court would have to find that when the minister says in his affidavits that my mind is, when the DG, the Director General says in the affidavit filed on behalf of the respondents that the department's mind is open, the minister's mind is open, and these applications will be considered on merit, the court would have to disbelieve those affidavits as not being truthful, and this all being a sham. That's the only way to get around this. But what I'm now going to refer to is a document which demonstrates that that is not the case. It's not a sham. From the outset, government made clear, and I'm going to take you to FA 8, where that is clear. The government made it clear that this wasn't just an off-the-cuff decision. It had given careful attention to how the decision had to be implemented. And it set in place various mechanisms and bodies, or communicated with different bodies, including the Zimbabwean government, as to how the decision would be implemented. So this was not government simply making an off-the-cuff decision, then washing its hands of the process. It gave careful attention as to how its decision had to be implemented with due regard for the rights and interests of affected persons. But by way of that long preface, can I take you to 010-371, the press statement? In paragraph 1 thereof, Justices, it says, as previously communicated, the Department of Home Affairs appointed the Departmental Advisory Committee, DAC, led by Dr. Cassius Lubisi, to assess the visa applications lodged by the affected Zimbabwean nationals. In other words, a specific advisory committee of the department was set up to assess the very applications which had been invited by the department and the minister when the decision was announced. This is not a sham. They set up a committee to assess and handle this. The DHA also appointed an outside legal firm to handle all court challenges relating to the decision not to extend the exemptions granted to the Zimbabwean nationals and related matters. Then under progress report, the Minister of Home Affairs received a progress report from Dr. Cassius Lubisi. The report states that the DAC has met on several occasions in order to execute its mandate, and their last meeting was held for the whole day on 1 September 2022. The DAC recommended, I'm sorry, there's still some audible interference. I hope that's not disturbing the court hearing me.
No, I can hear you clearly.
As the court pleases.
Mr.
Their last meeting was held for the whole day on 1 September. The DAC recommended to the minister that in view of the progress thus far, it will be prudent for the minister to consider extending the period within which the affected Zimbabwean nationals will have an opportunity to apply for visas and/or waivers for a further 6 months. The minister has carefully considered the request and decided to extend the period by a further 6 months, that is 31 December 2022 to 30 June 2023. Now, Justices, and sorry, can I just, it's important I go to the next page, 372. Another factor considered by the minister is that few Zimbabwean nationals have thus far applied for visas and waivers. To this end, the minister has issued another directive annexed here to Marked A. The minister is committed to affording the affected Zimbabwean nationals another opportunity to apply for one or other visas and/or waivers provided for in the Act. The directive containing the decision of the minister will be communicated through diplomatic channels to the Zimbabwean ambassador in South Africa. Now, Justices, this press statement and the accompanying directive, which is Directive 2, in September 2022, is instructive for at least 2 reasons, as I've alluded to. The first is that far from being the sham that is suggested by the applicants and the minister being closed to any further, and I use the word deliberately, waiver applications as opposed to exemptions, and certainly blanket exemptions. This makes it clear that not only is a specific committee set up to deal with these matters, but in fact, the minister is told that more time is required to consider the applications already received. And then the minister himself, it seems, decides that a further reason is to allow more Zimbabweans or more affected individuals to apply. In other words, those who had not applied as at September. And that's the second reason for the extension, the 6-month extension. So that demonstrates, we submit 2 things, that there is no sham here. The government is committed to properly considering, even requiring more time to do so, the representations received in the applications. That's the first thing that it's instructive about conveying. And the second is that this is an entirely rational process that's being followed. The process being followed with regard to the implementation, and again, this goes to the question of purpose and means. The purpose is to bring an end to the blanket exemption, but the purpose is also to afford, or the purpose is to allow individual consideration of individual circumstances. And that purpose is achieved by the means adopted, and one of those means is Directive 2, which is an extension of 6 months, tailored precisely in order to properly give attention to both applications already received or representations, and to extend a period for the obtaining of further applications. And that, we submit, is as far away from being irrational or insensitive to the requirements of affected persons as one can be. There was no obligation on government to extend the period by a further 6 months, but yet it chose to do so, it elected to do so rather, precisely to make sure that the affected individuals were afforded a proper opportunity to put their case to government. Justice, I see it's now 11:20. I don't know whether you intend taking the tea adjournment. I will be going on for a while, so.
Yes, Mr. Jamie, thank you. Let's take the tea adjournment and we'll reconvene at 25 to 11.
As the court pleases.
Or 25 to 12 rather. 15
25.
minutes from now.
As the court
Thank
pleases.
you. Thank you, Deborah. Let me know when everybody's online.
I will do so, Judge Collins.
Sorry, Justice Collis, I'm not sure whether we're waiting for anyone still. We are ready to proceed.
I think I'm also ready. I just thought I should be told if all the
No.
judges are online.
Judge, I've just admitted Justice Malindi. That's why I didn't inform you yet that.
Okay. Then we can proceed then. Thank you, Mr. Jamie. Are we recording?
Yes, we
Deborah,
are, my lady. Yes, we are.
we proceed, Mr. Jamie.
As the court pleases. Justices, I thought it appropriate before turning to the facts to just deal with this question of rationality and the proper degree of scrutiny, because it's been raised by Judge Mortar, and it is, in our submission, important to bear the appropriate standard in mind, that the court will look at the minister's decision through the lens of which the court will look at the minister's decision. Hoekstra deals with it. at page 492. As I say, these references will be given to the court, where after discussing various judgments, she refers to the Law Society case, and that is Law Society of South Africa v. President of the Republic of South Africa, reported at 2019-3, SA 30cc. With reference, and we'll give you those references, with reference to that case, she says that the apparent contradictions in the jurisprudence were ultimately accounted for in the Law Society case, where the Constitutional Court distinguished between procedural fairness and procedural rationality. You'll recall my learned friend Mr. Budlander referred to that yesterday and accepted, as he must, that procedural rationality is not the same as procedural fairness. And Hoekstra says the court defined the former, that's procedural fairness, very specifically as affording a party likely to be disadvantaged by the outcome the opportunity to be properly represented and fairly heard before an adverse decision is rendered. And that is, you will recall from yesterday's arguments, that is effectively the standard that the applicants want the court to hold the government's or the minister's decision to. And then Hoekstra goes on, procedural rationality, on the other hand, addressed the need for a rational connection in relation to both the process and the decision itself between the exercise of a power and this purpose sought to be achieved by its exercise. And we accept that, and that is the standard that we say applies, not the standard that the applicants say applies. So the court will bear that in mind, Justices, and then...
Yes, remember, Counsel, their argument was that Baja applies under these circumstances. And under Baja, we agree you're talking about procedural fairness, as opposed to your submission that Baja doesn't even see the light of day here because you're dealing with the policy decision. Then you'll just look at procedural rationality.
That is correct. That's one of the points of departure, one of the points of difference, fundamental points of difference.
Yes, but if you look at that case, the Law Society case, it brings in that point sharply that the court should look at procedural rationality. And the issue that they were raising was, do you look at before the decision is made or ex post facto, the consultations, the engagements, as it were, justifying the means with the end. That's where you also you lost them there. They feel that the horse is bolted, you are trying to close the stable door by giving these extensions. I understand you're saying these extensions, they deal with implementation. That one has been done away. ZEB has been done away with. It no longer exists. You're granting them an extension, 12 months initially, to regularize their stay, and then now 6 months. And you've also hinted that there's a possibility of another extension, even though you don't have instructions around that. Do I understand you well?
I said, Justice, that for purposes of the argument, we were prepared to accept that 30 June 2023 was the final date. It was always open, remains open to the Minister to extend that further, as he did at the end of last year. But that hasn't happened. So I'm prepared to accept that the matter must be argued on the basis that 30 June 2023 is the last date. But Justice Mota, I hear what you say, but I was about to take you to the content of procedural rationality, and it doesn't involve necessarily, if at all, an opportunity to be heard, let alone be heard before the decision. It requires, you'll recall, as we know, the focus in rationality analysis is the connection between means and ends, and is that a rational connection? And does the means chosen advance the ends? Because if they don't, as occurred in ETV, which I'm going to address, then the decision, is irrational. But before departing, and I'm not going to go to ETV yet, I'll get there. Can I just, well, sorry, I am going to go there, but just to refer to, because it's easy to do. You have a bundle of authorities, Justices, which our learned friends, HSF, I think, had uploaded to case lines, and ETV is to be found there at page 375 of that bundle. Sorry, are you there, Justices?
No, we're still trying to find the page. I don't think you've given us a correct reference. Can you direct us to the page, perhaps?
303.
Someone in your team.
303, Justices, at para 73.
What's the item on case lines, the numbering on case lines? Give us that first.
Oh, I'm terribly sorry. It is 029.
Yeah.
And the case begins at -384. And I'd like the court to go to 029-392. Oh, sorry, this reference is...
So what page are you referring us to of the case itself?
Case lines reference is 029-392. I can't see the page of...
392, okay, that's one.
And it's para 73. Does the court have that?
Yes.
So there, Justices, the Constitutional Court in ETV gives content with reference to democratic alliance of the content of procedural rationality. And the court says, the conclusion that the process must also be rational in that it must be rationally related to the achievement of the purpose for which the power is conferred is inescapable and an inevitable consequence of the understanding that rationality review is an evaluation of the relationship between means and ends. The means for achieving the purpose for which the power was conferred must include everything that is done to achieve the purpose, not only the decision employed to achieve the purpose, but also everything done in the process of taking that decision constitute means toward the attainment of the purpose for which the power was conferred. And as we submit, Justices, I've alluded to it already, but I'm going to deal with it in greater detail. The means adopted for the achievement of the purpose, which was, I repeat, a legitimate government purpose, namely to bring an end to the blanket exemption, was to first make it clear that there would be such an end, and secondly, to afford affected individuals an individualized opportunity of 12 months for the purposes I've already discussed, to regularize their affairs and or to make representations or apply for waivers, and that was subsequently extended for 6 months. That opportunity, I may add, was also afforded the opportunity to make representations to members of civil society, specifically African Amity and the Zimbabwe Diaspora Association. And as we know from the papers, Scalabrini, of their own initiative, engaged with the department, and I'm going to refer to that engagement, the details of it, because it's relevant in due course. And it was open to any other interested parties who purport to act on behalf or in the interests of affected individuals to engage with government as well. Government, it's quite clear from the correspondence with Scalabrini, welcomed that engagement and in fact asked Scalabrini to give inputs and make representations. So government was at all times open to engagement with civil society. And civil society, with respect, did not have to be specifically invited, to the extent that they had indicated an interest before. They were at liberty to, as did Scalabrini, engage with government. If I can then, Justices, deal with, having made those submissions, if we can deal with the facts pertaining to the decisions. The Court's aware that the first exemption regime, the DZP, was announced in April 2009 and ended, it began, I believe, only in 2010, but it ended in December 2014, so it was approximately 4 years. In its finding affidavit, the HSF refers to Annexure FA2, where in August 2014, Minister Gagaba reflected on the reasons for the DZP and also the genesis of the new dispensation, the ZSP. And that document is important with respect because it indicates and it supports the submission I made earlier as to the overtly political and policy-laden nature of the decision to have those exemptions in place in the first instance. The document FA2 is to be found at 001-87, FA2 to the filing affidavit of HSF. Does the Court have the document?
Yes, thank you, we have.
As the Court pleases. It records, second paragraph, in April 2009, the Cabinet of the Republic of South Africa approved the dispensation of Zimbabweans Project, or DZP, allowing Zimbabwean holders of this special permit to work, conduct business, and study in South Africa. The objectives were to, one, regularize Zimbabweans residing in South Africa illegally, curb the deportation of Zimbabweans who were in South Africa illegally, reduce pressure on the asylum seeker and refugee regime, and provide amnesty to Zimbabweans who obtain South African documents fraudulently. This was a significant gesture of support and solidarity with our neighboring country of Zimbabwe in response to the large number of Zimbabweans residing illegally in South Africa due to political and economic instability there. If I can just pause there, Justices, this underscores the point that I made about what a politically motivated decision it was to have this first dispensation and what the nature of the concerns were that it addressed. And then the document goes on, approximately 295,000 Zimbabweans applied for the permit, just over 245,000 permits were issued. The balance being denied due to lack of passports or non-fulfillment of other requirements. The permits began expiring on 31 December 2014. The approaching expiry date has caused anxiety for many permit holders, particularly those who are not ready to return to Zimbabwe as they contemplate their next steps. And the department has been considering the matter for some time. So government was aware in 2014, Justice, that the expiry of the first regime, the DZP, would obviously engender anxiety, uncertainty, etc. And thus, once again, it did the responsible thing by announcing a new regime. I emphasize a new regime in August 2014.
Instead of an extension.
Instead, Justice Malindi, precisely instead of an extension. And this is not a theme, but it's a submission that we will make repeatedly because, again, this case has been bedevilled with respect by loose language. And I don't only criticize my colleagues for the applicants in that regard. But words such as non-extension also is, I must accept, is also used by the department and the minister. Non-extension perhaps confuses the issue because extension and non-extension, those two words, those two phrases confuse the issue because there are no extensions. There's no doubt that the effect of these successive regimes is to extend the protection afforded thereby for an extended period from 2009.
Sorry, Mr. Jamie, I just want to know, is Judge Mota still online? Because his screen is frozen on my side.
I can see Judge Mota, but it...
No, I'm still online.
Okay.
It must be your screen. No, I can see you.
Okay, thank you.
All right.
As the court pleases. The fact that the protections afforded under the successive regimes from 2009 were continuous should not obscure the fact that these were successive regimes. And each time one ended, government decided, as a policy decision, not a legal decision, decided not because it was legally compelled to, but as a political policy decision to have another regime in place. It gave effect to that policy decision each time by invoking the provisions of Section 31(2)(b) of the Act. But that is implementation of the decision, not the decision itself. And none of these discrete decisions to have a new regime, including the very first one, were preceded by any sort of consultation with affected persons, with civil society, with members of the public. And that is the way justice's government works. It would be impossible for government because every day government functionaries take a myriad of decisions, and depending on how high up in government you go, these may be taken at a high policy level or a fairly mundane level. But at a high policy level, decisions of government to adopt a policy position, not adopt a policy position, adopt a controversial position, is not preceded by consultation or hearing parties. That would make government's position and government's business impossible. So government adopting a neutral stance on the war in Ukraine was not preceded by any public discourse, any requests for representations as to how government should react to that international crisis. And no one could sensibly suggest that it should have been. And the same way here, Justice, as I've made the submission before, no one could have gone to court to compel government to have the 2009 regime. And no one could have compelled government to go to court to have the 2014 regime, which was the ZSP. And the termination of the DZP came about by fluxion of time, operation of law, 31(2)(b), the exemption ran its course. And government, independently of that termination, decided to have a new exemption as a policy decision and implemented it via invoking Section 31(2)(b), without any consultation, without any request for anyone requesting a hearing, which again is sensible because it's a policy position being adopted. It's conferring rights. And government was not required prior to adopting its position in 2014 to have the ZSP to follow any public process, and it didn't. The reasons for that adoption are ongoing political considerations. So I'd like to take the court back to FA2, and where the minister, after saying that the department has been considering the matter for some time, this is at page 00187 still, the Minister Gagaba says, I recently met with my Zimbabwean counterpart, Minister Kemba Mohadi, to discuss matters of mutual concern, including the imminent expiry of the DZP. That demonstrates how it's a matter affecting South Africa's international relations with its neighbor. And then he says, while we note the ongoing political and economic recovery in Zimbabwe, consistently supported by the South African government, we are aware that it will take time for her to fully stabilize. A political assessment. That's not a legal assessment, Justices. if someone, and we know there are parties opposed to these regimes, dispensation regimes, in light of government being of that view, could anyone sensibly have come to court and expected to be entertained by a South African court saying, no, we say the recovery in Zimbabwe, political and economic, has been enough for her to stabilize, and you are wrong. You're acting irrationally in granting a new regime as ZSP. No. No one could have come to court and made such a case. But with the greatest of respect, that's precisely the case which is being made in this case by the applicants. They tell the court they disavow any attempt to have a permanent regime, but they invoke, and I'm going to get to their constitutional challenge, they invoke constitutional rights, which if they correct in their analysis, then the ZEP and similar regimes can never come to an end, because the rights of dignity and children are always going to be implicated. No matter how much you consult and give persons a hearing, those are either rights which can be asserted or they are not. And if they can be asserted, they will vitiate any possibility of these regimes or such a regime coming to an end. But they also invoke conditions in Zimbabwe, and they say, well, we say conditions in Zimbabwe have not improved. So to the extent that you can bring this regime to an end, and we require you to provide evidence to the court as to what you base that assessment on. And the only purpose of providing evidence to the court justices in this regard is to have a court assess the evidence. And I ask the court to consider for a moment how you would do that. Is this court going to sit as an arbiter of whether or not political conditions and economic conditions have improved in Zimbabwe to the extent that it is appropriate for government to decide to no longer have a blanket exemption for Zimbabweans? With the greatest of respect, I only need to put the question like that for the answer to be obvious. The answer is no. That's not what courts should do at all. It's not.
Jamie,
Yes, Justice Melody.
the applicants will correct me if I'm wrong. I understand their case to be that the minister has the power to terminate the regimes or the current exemption. But they submit that having so decided, the minister should have consulted on the impact it would have had on the people on whom constitutional rights had vested by being within the borders of South Africa. And therefore, they contend for a period of consultation on the implementation arising out of the termination, either by the decision of the minister or by a fluxion of time. Is that how you also understand it, or am I wrong?
No, I think that's the fair summation, Justice Malindi. They require consultation, notice, and opportunity to make representations and to be consulted. I'm not sure whether, in fact, as we understand the case, it's not before implementation, it's before the decision is taken at all. So they wanted, and that's always the way we've understood their case. It's not during the implementation period, because they couldn't argue that, because consultation and representations have been solicited and are happening during the, as I've gone to some lengths to explain. In fact, that process isn't complete yet, but that is happening, Justice Malindi. The consultation, the representations have been solicited, and as recently as September last year, further representations were solicited, and those are being considered by dedicated task teams and a committee that's set up to do that. So,
but they are saying that in anticipation of the coming to an end of a regime or the current regime, consultation should have taken place, either in anticipation or upon the
Before
coming into effect of the date of termination. And you also have submitted or taken us through the process of instituting or bringing about the successive regimes you've spoken to us about, that in anticipation of the coming to an end of each of these regimes, the government would then take a policy decision as to whether the circumstances still prevail for a new kind of regime, in your view, not the extension, but a new kind of regime. So the applicants are saying, in anticipation of the coming to an end of the ZEPs, or upon the coming to an end of the ZEPs, ministers should have consulted on the impact it would have had upon the rights that they have acquired.
we disagree, with great respect, with that legal submission and approach, Justice Malindi. We say that the impact is being considered in the implementation process, and that's the only way it could sensibly be done. The applicants, I don't want to say glibly, but they blithely, let me use a less offensive word, they blithely say what you've just put to me. The Zimbabwean, the ZEP holders should have been consulted, or we as civil society should have been consulted on impact before the minister took the policy decision. And we have a number of responses to that. One of them, as you know, being in the supplementary note that we put up, which is before a result eventuates by effluxion of time, operation of law, there is no legal requirement, and we've referred to the authorities, I'll refer to them briefly, to grant Audi. Where a result eventuates by operation of law, effluxion of time, the law doesn't require Audi. But quite apart from that, which is a legal argument, Justice, to go to the submission that you just, which is their submission, that there should have been consultation before 31 December 2021. That's their case. And that's why it was procedurally irrational and also in breach of PAJA. Our answer to that is that sets an insensible, impossible requirement on government. It's also not a requirement. If you're with us, and I'm going to address why we say it's not PAJA, because that's an important part of the argument, but before addressing that, on the assumption that it's not a PAJA review, then, let me make the submission more fundamentally. We submit that, and there are two bases for the submission. The first part of the submission is practically it is impossible to expect government to consult 178,000 permit holders, and we know that each holder has a number of dependents. So, and to the extent that an argument is made about children, etc., to consider the personal circumstances of 178,000 multiplied by 3 or 4, hundreds of thousands of persons before it adopts a policy position, that would render government's task simply impossible. It would never have been able to do that. It would have taken years to try to assess impact on that level, and that's not required by the law. It's an impossible burden, it's an insensible burden. What it did do, what government did do, Justice Malindi, is in its decision conveyed on 5 January 2022, it said this is our decision vis-a-vis the blanket exemption. And I've already said that made the position, government's position clear. We no longer deem this policy appropriate, these exemption regimes appropriate. That's a policy position, and we're making clear what our policy position is. But we are fully aware of the impact this will have, the disruption that it will have, and thus you are given, your permits are extended for 12 months, and you are invited to tell us if you're unhappy that this, or rather if you say this shouldn't apply to you, the termination, the non-extension, tell us why, give us your personal circumstances so we can assess it. Or if you say 12 months is insufficient, tell us that and the reasons, and we can assess it. And we can give individualized attention to your position Or if you wish to, you can regularize your affairs during the 12 months. That is where impact consideration occurs. It cannot occur, did not occur, I can't suggest it did, before. The minister, or before the end of the regime in December 2021. Obviously, the minister... I'm sorry.
I interrupted you. You had your own train of thought, but if you are going back there, having referred us to the ETV case, can you then separate, well, first of all, maybe inform me as to whether you are referring to ETV in order to deal with your submission on the policy-making decision on these regimes, or on the consultations processes that were called upon by government once a decision was taken not to institute a new regime. Which part of the two decisions are you referring ETV in reference to?
Sorry, Justice Malindi, could I just have that from you again? You put it to me, am I referring to ETV for support of, and you put two propositions, could I just make a note of this?
The policy decision on bringing about the various regimes, in particular the ZEP regime, or are you referring to ETV in order to support your submissions on the rationality of the consultation process?
Thank you, Justice Malindi. We rely on ETV for both propositions. And before I take it to ETV, can I just explain to the court what the relevance of ETV is in this case? ETV, as you know, Justices, was a case that dealt with the migration of TV signals from analog to digital. And it involved something called a set-top box, I think it was STB. And the relevant facts in ETV was that since 2015, the government had announced, and this goes to the first question that you put to me, the relevance of ETV in relation to a policy decision. So in 2015, Justice Malindi, the government announced that there would be this migration from analog to digital. So in other words, it made it clear that's what the policy decision was, and now it was for the decision to be implemented. And at that point, it also undertook publicly to assist indigent households or poorer households with subsidized STBs, because the STB was necessary to effect this migration, unless you got a digital TV. If you didn't have a digital TV, you needed a box on top of your old TV. And the government undertook to assist with provision of these boxes. And then things labored on for a long time, and it took a very long time. Deadlines were missed, etc. And finally, I think it was in 2021, government announced a switch-off date for the migration, which was a very short switch-off date. And before announcing that switch-off date, it first gave no notice to anyone that that was going to be the switch-off date. And secondly, it gathered no information about how many persons would be left, poor households would be left without television signal because they hadn't had an opportunity or hadn't been told, and this was the point, that they'd not been told the switch-off date is now X. And thus, if you haven't already applied for an STB, subsidized STB, you should do so. So those were the circumstances under which ETV was decided. And as to your first point, Justice Malindi, it's clear from the judgment that no consultation was held with anyone before government decided on its policy that there would be migration from analog to digital. There was no consultation. And that speaks to our position, our submission with regard to the adoption of a policy to exempt Zimbabweans or not. There's no requirement that you have at that early stage consultation, and that would make, I repeat, government's job unworkable and is not a practical or sensible way to go about it, and it's not a legal requirement. Now, to go to the second aspect, the rationality of the decision at issue in ETV, the decision that was challenged is not the adoption of the policy to migrate from analog to digital. That's not the challenge. The decision that was challenged in ETV was the setting of the cutoff date for that process. Now, if I could take you to ETV, it's, as I've said already, it's 29-029-384. And does the court have it? 029-384. If the court would go to 029-386 at para 16, the court there summarizes the applicant's argument, namely that the minister had a duty to consult with various interested parties and stakeholders, inclusive of the applicants, before announcing the analog switch-off date. So that's what they required consultation about, not about the initial decision to have the policy announced, which was the migration itself. It was when was the end point of this migration. In other words, what is the switch-off date beyond which you won't be able to get analog signal? That was the issue. And the court at para 24 couches the issues quite correctly, we submit, as follows, under C Roman 3, as the issues in the case. If the minister's power is an executive one, which we say it is with regard to the policy decision, did the minister act rationally? If the power is administrative in nature, and only then, justices, did the minister adequately consult, as required by PAJA, before taking the decision to determine the analog switch-off date. So that's the way the debate is couched. And then if I can ask the court to go to 029-388. Where the court says, in the final sentence of para 35, sorry, not the final sentence, the second last sentence. In my view, this power, the power to set the cutoff date, is located within the minister's original constitutionally policymaking powers, which is section 84(2)(c) of the Constitution. That is a typographical error in the judgment, justices. It should be 85(2)(b) of the Constitution, deals with original policymaking powers. And the court goes on to say, this section empowers the minister to develop and implement national policy. This much was undisputed. And then in para 36, the determination of the analog switch-off date is the implementation of the BDM policy by the minister. In my view, the minister's exercise of power when determining the analog switch-off date is thus executive in nature. Appropriate judicial deference should therefore be shown by this court. The question is then whether the minister exercised this power rationally and lawfully. And then the court goes on, justices, to deal with the facts. I've already referred you to para 73, where the court deals with the content of the rationality inquiry. And then lower on that page, which is 029-392, you have the reasoning of the court which leads to its ultimate finding of irrationality, a disconnect between means and ends. Because the means chosen was giving persons this period since 2015 to say we're going to migrate, and then ultimately providing a cutoff. Those were the means. And the purpose was an unobjectionable purpose in terms of the Constitution, the law, in fact, it was in terms of South Africa's accession to various international agreements, which required us to move from analog to digital. So it was a legal requirement at international law that we move. And in order to give effect to that obligation to comply with our treaty obligations, we put in place this process, and then the court reasons with regard to rationality. You find the reasoning at paras 76 and 77, Justice Malindi. The court says at paras 76, the Minister therefore recognised that for a successful migration process to be achieved, persons who are required to migrate to digital can do so and will not be negatively affected by the analog switch-off. The number of households which are required to register for STBs is accordingly without a doubt a relevant consideration. The second inquiry, this is the three requirements my learned friend alluded to yesterday, which are to be found in Democratic Alliance. The court says the second inquiry, whether the failure to consider the material concern is rationally related to the purpose for which the power was conferred, also tells against the Minister's decision. It cannot be said that the Minister's failure to adequately provide an opportunity for persons to be informed about the need to register before the deadline, and thus to obtain accurate information about households requiring STBs, is rationally connected to a successful migration process. Without obtaining and considering such information, the Minister was not in a position to determine an analog switch-off date that would mitigate the harm caused by such a switch-off. And then the rest of the wording on that line is obscured by the case line's reference. But something about register accepted was among the central goals of a successful migration process. So in other words, the manner in which the Minister acted in this matter by setting a cut-off date without eliciting the necessary information about the number of persons affected rendered the decision irrational. Now, to transpose those principles to our case, Justice Malindi, we stand on a totally different footing to the situation in ETV. In this case, the Minister and everyone else was aware from 2017 that the regime brought into existence by the ZEP was going to come to an end on 31 December 2021. Everyone knew that. It was no surprise. And given confusion, as we've alluded to in the past about the ending of these regimes, the Minister in September 2021 takes a decision, no further blanket exemption. That decision is announced. And persons are then given an opportunity, justices, as I've referred to repeatedly, to regularize their position or to make individualized representations and apply for waivers. So those are the means adopted to give effect to government's purpose, which is to bring an end to the blanket regime. And we say that decision, the court may think there may have been other ways to do it, but we know from the jurisprudence that's not the correct test or approach. The only question is, we're not dealing with reasonableness, we're dealing with rationality. The only question is there a rational connection between the means chosen and the purpose? And we submit clearly there is. It can't be argued that there isn't. The means chosen both make it clear to everyone what the position is, so there's no confusion, and gives them a substantive opportunity to regularize themselves or to bring their individual circumstances under government's attention so government can react individually. And the suggestion that that is a sham is belied by the facts that I've referred you to, inter alia the press statement accompanying Directive 2, which makes it clear that government was not going through the motions. It actually was actively prepared to, making plans to, and intended to consider individual representations. And taken as a whole, that is a rational decision. And if you add to that, Justices, the reasons given by government, which I'm going to still take you to, for its decision, ultimately and overall, this decision was rational. It certainly was lawful. No one suggested it wasn't lawful, except, sorry, for the truck drivers. But the decision was, and Mr. Rosenberg will deal with that, but the decision was lawful, we submit, and it was rational. It was rationally motivated. It had a rational and clear connection, which, unlike ETV, advances the purpose, not detracts from it. In ETV, the means chosen detracted from the purpose of having an effective migration. Here, Justices, the means chosen gives full rights of RD at the appropriate time, which is when you must consider individual circumstances. You could not have asked, and there's no legal requirement, and as I say, I'm going to take you to the scenario where a regime comes to an end. And we submit that where a regime comes to an end, as I've submitted, there's no RD required. And also before government takes a policy decision, just as in ETV, there's no RD required before government takes a policy decision. In implementing the decision, we accept RD applies, and here RD is given. It's given extensively. It is in fact still being given, and those RD rights are still being exercised. I don't know whether I've answered your question, Justice Malindi.
Thank you very much, Mr. Chairman. You have.
As the court pleases. Could I then take the court, if I may, because I've alluded to it a number of times, so let me just deal with this and then we can move on to the factual analysis. We've made the submission in our supplementary note that...
Sorry, Mr. Chairman, before you proceed, I just want to find out, how are you on your time, your allocated time? I'm getting concerned, but I think some of the court's questions is also detracting you from your argument, but I just want to know how much time on your calculation do you still have left for your argument?
I forget what we agreed. Was if I was going to have...
You were going to have 3.5 hours, I think. Or 3 hours, yeah, 3.5 hours, just about.
Myself and Mr. Rosenberg.
Yes. Your entire time.
Well, then, if we began, Justice, which we did at 10 o'clock, and then we took, I think, slightly more than 15 minutes. We took maybe 25 minutes for tea. But if we began at 10, I've been going for just over 2 hours, I think. Mr. Rosenberg has indicated he'll require no more than half an hour.
You said, sorry, you said altogether you'll take 2.5 hours, Mr. Jamie?
We said altogether we'll take 2.5.
Yeah,
so I've been on
the minister's side.
So I've been busy for 2 hours, Justice Collis.
Okay.
Are you prepared to give us any further time?
Yeah, you will get further time. I just want to find out whether there will be sufficient time left for the others to reply. Because you said Advocate Rosenberg is also going to present part of your argument on behalf of the minister.
He'll present argument, he says, for about half an hour, Justice.
Half an hour for that, okay.
In relation to the truckers matter.
Yeah, so would you be able to finish, well, this half an hour now, and then Rosenberg can start once we come back from lunch? Then we should be able to cover everything, if you can do that.
So you'd like me to finish by lunchtime, Justice? I'm happy to do that.
Okay, thank you, Mr. James.
I'm then going to obviously confine my arguments. So I can't make all the arguments, but I'll try to concentrate on what we consider important, and that's the rationality aspect, and I've referred to the facts in that regard. So let me go on to a different aspect, and that is this question that we, or this issue that we raise, and it's raised in the context of not a dispensation, a situation or a consequence arising by effluxion of time or operation of law. We uploaded a note on case lines, Justices, on Sunday, I think it was, over the weekend. Could I ask whether the court has that? I don't have a case lines reference.
Yes, we do have it. It was just uploaded upside down, but we do have it.
I'm sorry, Justice. I hope the content is not upside down.
No, we have to have it printed, but it is on Coastline. Thank you.
I don't.
It's under 60.
60.
I think 60. Just want to get to it. Well, 60. It's just under on case lines, just after the actual court's directives. Then you have the first 60, the second 60 on case lines.
Could I just ask? Could I just ask?
060. 60, Mr. Jamie.
Yes, and page, Justice.
-1 is the introduction.
001 or just 1.
060-1.
1. And then I presume 2.
No.
I don't have it as 060. It's just 60, but there's 260. So it's the second 60 on
Second
case line.
60, yes.
Yes.
Yeah, but after the hyphen is it page 1 and then 2.
Page 1, yeah. Dash 2 and whatever. So I don't know which page you want to take the board to.
Yes, I'm just trying to number mine because mine is not on case lines. I just printed a copy. So then, Justices, it would be 060-1 is the first page.
No, it's 60-5. That's where your document actually starts. Sorry.
-5.
Yes. The first few pages is just the filing sheet of the document.
Sorry. Sorry, Justices, I'm technologically challenged.
That's fine. All I'm saying is there we go, yeah. So it's 60-5, that's where the document starts.
Yes. Could I ask the court then to go to 60-6, Justices? We reference, and I haven't taken you to it, but I should briefly just refer to the provisions of the Act, because however you construe it ultimately as administrative action or as executive action, as we contend for, the court must be alive to the fact that the implementation of the decision and having taken the policy decision, it's giving effect to the decision was taken under the provisions of the Act, and everyone's accepted that, and everyone's referred to Section 31(2), and except for the truckers, everyone accepts that these permissions, etc., were granted in terms of the Act. So I asked the court to have particular regard to the terminology of 31(2)(b), the language of 31(2)(b). Grant a foreigner or category of foreigners the rights of permanent residence, and then these are the words, for a specified or unspecified period when special circumstances exist. Now, that is what the Minister purported to do in each of the 3 iterations of the exemption regime. And in each case, the Minister elected to have the rights granted for a specified period. And we know that in the case of the ZEP, that was 31 December 2021. And we make the submission in our note, Justices, at page 6. At para 4, we say the ZEP was due to expire on 31 December 2021. This expiration would have occurred by fluxion of time and or operation of law. The Minister, however, elected to exercise his powers in terms of Section 31(2)(b) to extend the period of validity of the ZEP first to 31 December 2022, Directive 1, and subsequently to 30 June. And then in para 6 on page 7, we contend for the reasons which follow below that where the non-continuation of the ZEP as a blanket regime arises by the effluxion of time and or the operation of law, the Audi principle is not implicated. We refer to Beniti, Supreme Court of Appeal decision, where it cited Minister van Onderwys Kultuur v. Low, another decision of the then Appellate Division, which held, as translated in Paniti, the deeming provision of Section 72(1) comes into operation if a person in the position of the respondent without the consent of the head of education is absent from his service for more than 30 consecutive days. Whether these requirements have been satisfied is objectively determinable. There is then no question of a review of an administrative decision. Indeed, the coming into operation of the deeming provision is not dependent upon any decision. There is thus no room for reliance on the Hardy rule, which in its classic formulation is applicable when an administrative and discretionary decision may detrimentally affect rights, privileges, or liberty of a person. And that, we submit, is the operative principle, Justices, and the court in Paniti so found. We cite that in para 9 of the note at page 8. Where at para 10 of the judgment in Paniti, the court says, in my view, the low judgment is definitive of the first issue in the present matter, whether the applicant's discharge constitutes an administrative act. There was no suggestion that Low was wrongly decided. There being no decision or administrative act capable of review and setting aside, the second part of the first prayer in casu, viz. That the decision be declared an unfair labour practice, falls away. And we submit the same occurs here. The ZEP did not come to an end, we emphasise, Justices, because of anything the Minister did. It came to an end because of the internal condition and the time limit subject to which it was granted, that it would end on 31 December. That's when it came to an end. There was no additional decision by the Minister to end it, which is the premise of the relief sought by both HSF and COMSA. They couched the decision as one to terminate, and there was no decision to terminate. The decision happened by operation of law. If you're with us in that regard, then Audi doesn't arise in respect of that decision. And that's an additional reason, quite apart from the fact that, and I'm going to turn to that question now, Justices, because it's important, given the limited time, that I do deal with it. And that's the question of PARJA and why PARJA doesn't apply. But we rely on Paniti and sorry, I don't know whether I made the point. Paniti and Low were approved of by the Constitutional Court in the Grootboom v. National Prosecuting Authority judgment, which is referred to at para 10 of our notes at page 8, the case lines page 8. In dealing with that, in my learned friend Mr. Budlander's written argument, he attempts to deal with it at para 54 of his argument, where he refers to two SCA authorities, and sorry, I don't have the case lines numbering for his notes or his oral address. I don't know whether he uploaded it to case lines.
Are you referring to his oral note?
I am
yesterday, Mr. Jamie?
I am Justice. Sorry.
All right, it's under 060.
My lady, if it would assist
Page
the page
30.
my learned friend
Sorry.
the page my learned friend is looking for is 060-17.
I'm indebted to my learned friend. He relies, it's page 17 of the, sorry, just
The document.
these
Thank
two
you.
from my law reports. 2018-2 and 2018-6, 2 and 6, just pull them quickly. Justices, he relies on two cases. Just give me, don't look for the reference, just give me 2018-2 and 2018-6 volumes, they're bound. So I'm just attempting to get the two
Decisions, all right.
the two decisions, Justices. Thank you. The first one, the Medi, So the proposition that he puts up is that even where termination occurs by a fraction of time, a decision maker's refusal to act to reverse that automatic consequence has in certain circumstances been held to be an administrative act attracting the right to a fair hearing. We don't quibble with that statement, but it doesn't assist and it's not relevant to our circumstances and facts. Because as he acknowledges in his submission, it's where, or rather, it's not clear from his submission, but he's talking about a subsequent refusal to act to reverse the automatic consequence. Now, that's a different question, just notionally, to the question of whether the initial act, or rather the initial consequence, where the decision arises or the consequence arises by a fraction of time, is subject, and that's what the debate is. We say that where the consequence arises by a fraction of time operation of law, that is not subject to ARDI, because there is no decision. It's operation of law. Now, they don't meet that by saying, or that proposition of law isn't met by saying, well, a subsequent refusal to act to reverse that automatic consequence, that has been held to be admin action. So at the level of just plain language and logic, our submission is not met. But just to deal with the cases on the merits, the first is Mamasedi, 2018-2, 305 justices. And I don't think you have the case uploaded yet. I think my learned friend said he would. And he cites para 15. The court in that case does indeed find, the court says in para 15, the investigation of the, and what happened here was that a member of the South African Defence Force was found to have breached. In fact, what was relevant was section 59.3 of the Defence Act, provides that if a member of the Defence Force is absent from official duty without permission of his or her commanding officer for a period of 30 days, then he or she is regarded as having been dismissed on account of misconduct. So that's what that's what the provision said. You are regarded as having been dismissed for conduct, but then at the end of section 59.3, it concludes, after saying that you are regarded as having discharged misconduct, it says, but the Chief of the Defence Force may, on good cause shown, authorize the reinstatement of such member on such conditions as he or her may determine. And it was in the course of such an inquiry was set up to determine whether or not the Chief of the Army, Defence Force rather, should so determine, consequent to the person being discharged. And it was that investigation, the subsequent investigation, that at para 15, the Supreme Court of Appeal holds that is administrative action, or because it involved a full-on inquiry, representation, legal representation, and so forth. So that doesn't assist with the first proposition that the discharge of the member in terms of 59.3 of the Act happened by operation of law without any ARDI and without a separate discrete decision being taken. And then the second decision that our learned friend relies upon, Zulu, the proposition in 54.2 of my learned friend's note at 17 to 18 says that in that case, the Supreme Court of Appeal held that the decision not to renew the fixed-term contract of a soldier whose contract was set to expire by a fraction of time was also an administrative act that attracted the right to a fair hearing. He refers to para 51 justices. And it's indeed so. In that paragraph, the court, the Wallace J.A. says, counsel did not seriously contend that the decision not to renew Mr. Zulu's contract was not vulnerable to attack on departure. But what precedes that, justices, is a discussion of the facts of the matter. And from those facts, it is clear that clause 17 of the relevant policy that was at issue in the matter. I just want to make sure that I'm referring to the correct. Yes, the policy that was at issue in the matter is to be found in para 24 of the judgment, Justice, and in short, it provided that when the need exists for the non-renewal of the fixed-term contract of a member, the following administrative actions must be effected. And you find it in para 24. I'm not going to read through all of it, but essentially it provided for a process to be followed, which included the commanding officer must substantiate the reason for the non-refusal of the fixed-term contract by completing a report into the events which have led to his or her decision. And it's that process which the court found was clearly vulnerable to attack under PAJA, not the non-renewal itself. The non-renewal itself came about, Justice, by operation of law. As I just want to find a clear reference to that. Sorry, the relevant, and if there's another provision or paragraph of the case I need to refer to, I'll ask leave to do that in the subsequent note I've referred to. But at para 11 of the judgment, the court records that the letter, which is referred to in the judgment, correctly stated that the terms of the contract did not provide for an automatic extension, so there was an employment contract, on its expiry. That emerged from the service agreement, which provided a member shall be informed at least 18 months prior to the lapsing of his or her contract of the intention of the SANDF to offer a subsequent employment contract or not. There is no obligation on the DoD to offer a subsequent contract when the said period of employment lapses. And then the court goes on in para 12, while under no obligation to offer an extension of the contract, the quoted provision indicated that the SANDF would engage in a process in which it would consider whether to offer such a contract and would do so at least 18 months before the existing contract was due to expire. So it was that process.
Sorry, Mr. Jamie, I lost connectivity. I just wanted you to repeat what you're reading from, which paragraph in the Kulu judgment.
In the Kulu judgment, para 11, Justice Collins, I don't know when you lost me.
Well, it's probably 2 minutes ago or so. I'd indicated I'd lost connectivity.
I'm sorry.
But there was no response from anybody on the platform.
Possibly because you lost connectivity, Justice. We didn't hear you. But could I just repeat what I've said about para 11 or refer to para 11? Para 11 of the judgment in Kulu, the court says, with reference to a letter that's referred to in the judgment, the letter correctly stated that the terms of Mr. Zulu's contract, Mr. Kulu's contract, did not provide for an automatic extension on its expiry. So it did not provide for an automatic extension on its expiry. That emerged from his service agreement, which provided a member shall be informed at least 18 months prior to the lapsing of his contract of the intention of the SANDF to offer a subsequent employment contract or not. There is no obligation.
I think Justice Collins has frozen, hey?
I can see her moving on my screen, Justice Malindi, although she's frozen.
Yes. I can hear you now,
Justice
Mr.
Collins.
Jamie. I had an indication of
Yeah,
poor
now she's
connectivity,
moving.
but I can hear you.
May I proceed, Justices?
Yes, you may. On my side, yes.
Justice Morto, you've been frozen on my screen for quite a while. Can you hear me, Justice? And Justice Collis, can you hear me?
Mr. Jamie?
Yes, Justice. Can I proceed?
Sorry, I think, can we take the luncheon adjournment now, because I keep on losing you. It's 5 minutes to 1, and then we'll get when we reconvene after lunch.
As the court pleases. As the court pleases.
You're in.
But how did you get me back in now so quickly? Because VPN is still going.
No, I changed profiles.
So where am I now?
You are now connected with this one. This OCJ,
Okay.
this is not the bottom one.
The top one.
Yes.
So
That's what I do. I try all those profiles until I'm
So you
able
think
to.
it's a different one now?
Yes.
I mean, so you think it would be fine?
And see. But I will just text Silpo to let him know that we're really struggling with networking.
Judge Collis, just a heads up that you're not on mute.
Thank you. Thank you, Deborah. I'm ready to proceed.
As it pleases the court, I can see Judge Malindi. Justices, good afternoon.
Apologies, my lady, I got disconnected for a bit. Can you hear me, Judge Collis?
Yes, I can. Are we still recording?
It looks,
Or can we proceed, or you need to sort out your connectivity? What's the challenge?
It was,
It looks
I
like this-
was nearly kicked out, but I'm back now, my lady, and I confirmed that this is still matter case number 32323 of 2020, my lady. May it please the court.
All right. Mr. Jamie?
As the court pleases. Justices, I'm aware that I have run out of time, so I'm going to try to be as quick as I can and just perhaps give you reference to the remaining points. As I've indicated, I'm not going to have time to deal with all the submissions, but our submissions are in the heads of argument, and we stand by those. If I may proceed and just take up where I left off and just finish the point in reference to the Kulu case, which is where I think I was. That was a case, Justices, where I think I was about to go to para 12 of the judgment, where the court says that after referring to the contract, which provided that a member shall be informed at least 18 months prior to the lapsing of the contract of the intention of the SANDF to offer a subsequent employment contract or not. And there's no obligation on the DoD to offer a subsequent contract when the set period of employment lapses. It's with reference to that provision that the court at para 12 says, while under no obligation to offer an extension of the contract, the quoted provision indicated that the SANDF would engage in a process in which it would consider whether to offer such a contract and would do so at least 18 months before the existing contract was due to expire. And it's with reference to that provision and that opportunity that the court says in para 51, which our learned friends quote in purported meeting our submission that the contract, or that where there's a cessation by operation of law or effluxion of time, there's no separate Audi or admin law principles invoked. The court, apropos that opportunity in the contract itself, says at para 51, counsel did not seriously contend that the decision not to renew Mr. Kulu's contract was not vulnerable to attack on departure. So once again, it's the subsequent decision to not renew, which was expressly provided for in the contract and in the other case relied on in the notes, expressly provided for in section 59.3 of the Defence Act itself. The exercise of those powers involved administrative action, not the anterior decision. So we stand by with respect to our submissions in that regard. I'm now going to go, Justices, on to the remaining points I want to address. They are effectively fivefold. The one is just to give you references with regard to our submission that PARJA is not applicable here. And we make that submission in the context of our already dealing with the nature of the decision, which we've outlined at some length, and the policy-laden and executive nature of the decision. We say that under those circumstances, it is clearly executive, it is not a PARJA decision. So that's the first point. The second point we want to deal with, Justices, is the question of, well, just we're not going to deal with it because I submit it's been dealt with, but dealing with the three grounds, the principal grounds that you heard argument from our learned friends for the applicants on, the three grounds of challenge, namely procedural fairness, the impact on ZEP holders and their children, and then the limitation of constitutional rights. I'm going to make brief submissions in that regard. Once again, we've dealt with it in extenso in our heads of argument, and we stand by those submissions. And then finally, I am going to, as I alluded to earlier, take the court to the correspondence with Scalabrini, between the department and Scalabrini, which deals with the question of whether or not the minister, whether that evidences the minister having closed his mind to any representations that may be made on behalf of ZEP holders. And we submit that will demonstrate that he hasn't. So if I can go to deal with the Parja point first, Justices, and ask the court or yes, could ask the court to go to the bundle once again that's been uploaded by our learned friends for HSF, the authorities bundle, and in particular to the Scalabrini judgment, which is to be found at 029-952, and then the relevant paragraph I want to refer to, Justices, is paragraph 27 and 28 of that judgment, which you find at 029-955. Have it, Justice?
Thank you. You said paragraph 27?
Yes, 27.
28.
27 and 28.
Thank you.
In that judgment, at those paragraphs, the court says, Skipper's AJA, as he then was, says the following. And you'll recall this case was about the closing of a refugee reception centre in Cape Town. And the court says, the appellants accept, as they must, that the question whether refugee reception office is necessary for achieving the purposes of the Act is quintessentially one of policy. It concerns the manner in which the state determines how it will discharge its international law obligations contained in the Act. The number and locality of refugee reception offices involve an assessment of the need for such facilities, the number of refugee reception offices, refugee status determination offices, and other staff required, and issues relating to administrative effectiveness and efficiency, budgetary constraints, and policies of the department. Thus, a decision to close a refugee reception office in terms of 8(1)(c) of the Act constitutes executive rather than administrative action and is not subject to PAJA. And the next reference I want to take you to, Justices, is Hoekstra in dealing with this self-same question at page 245 to 246 of her work, the third edition thereof, has the following to say. So, as I've said, we'll give you a note to this effect. Having discussed the jurisprudence, she says, at 245, it is only those matters that go to the heart of the executive's role and in respect of which one would expect democratic or political accountability to predominate over legal accountability that should be excluded from the ambit of administrative action on the basis of their executive nature. It follows that the factors that should carry the most weight in distinguishing administrative action from executive action are the extent to which the decision involves policy formulation, is otherwise heavily politically policy-led, or is a matter of political judgment, not in the sense that it is politically controversial or the subject of party political debate, but rather in the sense that it should probably be subject to political accountability rather than to legal accountability provided that the decision maker does not exceed the bounds of legality. That being the case, it seems to us that the category of executive actions is relatively narrow. It is limited to matters of high policy or high politics that lie at the heart of executive power, such that it would be inappropriate to subject them to administrative law scrutiny. Examples would include matters of economic or foreign policy, the decision to prefer renewable energy over coal in the energy mix, or decision to privatize a state asset. It would also, as the PARJA makes clear, include the calling of a referendum and the appointment or dismissal of cabinet members. With respect, we entirely agree with that analysis and that description, and we allude and refer to what I've already said this morning, Justices, about the policy-led and political nature of this decision, its implication for the government's assessment of our national interests and our political relations internally with Zimbabwe. This decision was stated in terms to be in advancement of the government's foreign policy, and I just want to, yes, I don't expect the court to go there, but can I just reference this? FA2 that I've already referred to at page 001-87, the last line on that page says the following, and this is the remarks by Minister Gigaba on the announcement of the ZSP in Pretoria, 12 August 2014. In the last line of that, he says, our management of immigration is also informed by our foreign policy, one feature of which is Pan-Africanism. So in referencing the reasons for these dispensations, one of the reasons expressly given by the government is its advancement of its foreign policy, a feature of which is Pan-Africanism. And I began my submissions, or early on in my submissions, I referred to separation of powers, and with respect, this just brings it into stark relief how politically charged the decision to have these dispensations is political, executive, not administrative action, as is the decision to, or rather the coming to an end, and the decision of the minister to not put a new dispensation in place, permanent dispensation, because government had decided it was no longer appropriate to have a blanket exemption. They go to the heartland, we submit, of government decision-making of a political policy-led in nature. They are clearly not administrative action. Then to deal, Justices, with, so that is our submission, those are submissions with regard to administrative action, PARJA. With regard to the procedural fairness argument or rationality argument, I believe I've dealt with that extensively. We submit, for the reasons that we've already given, that the decision was clearly rational, both in its content and by the selection of the means provided to obtain the result that government sought, namely to bring the exemption regime to an end in an orderly but yet fair manner. And it was designed to achieve that purpose. It includes, it was also procedurally fair if the court were to want to go to that degree of scrutiny, which obviously arises under PARJA, which we've submitted does not apply. But if the court were to go there, the requirements of PARJA require notice, a fair opportunity to make representations, and the opportunity, or not opportunity, the expectation of those representations will be properly considered by the relevant authority. All of those are part of the government's decision and is encompassed in the 12-month extension and the conditions attached thereto. We've dealt with that. We submit that constitutes a procedurally fair process. There's never been a substantive attack, as we understand it, on the 12 months as such, or on the 6-month extension, in other words, the 18-month period. It's not the case that, well, that is not long enough. But if that is to be argued, we submit it is long enough, and the process, I repeat, is not yet complete. It's inchoate, so it cannot be challenged in our submission at this stage, and no facts or insufficient facts are put up for that challenge. The third aspect I wish to deal with is the limitation of constitutional rights arguments. As the court is aware, and we've dealt with the response to this in our heads of argument, there are two essential bases for the argument. The one is its limitation of the rights to dignity of ZEP holders, and the second is the impact and the limitation of children's rights. With regard to dignity, Justices, we submit that it would be incongruous, if not perverse, to argue that the extension of a temporarily limited regime, such as the ZEP, which confers rights, but always for a temporary period, and they include rights which are ordinarily only available to citizens. Those rights were accorded to Zimbabweans who would otherwise not qualify for those rights. They include, Justices, rights to sojourn in the country, and to have, they include the right to remain in and to reside anywhere in the Republic, which is a right in terms of Section 21(3) of the Constitution, is only afforded to citizens. And they also allow holders of the right to work and to choose a trade, occupation, or profession, which is a right also only accorded to citizens in terms of Section 22 of the Constitution. And the other rights that that exemption provides. Now, it is fundamentally at odds, we submit, with the entire legislative scheme, and it is perverse, and I say that deliberately without meaning to be insulting to anyone, to argue that, well, you are under no obligation to give us this exemption, but you do decide to give it to us for political reasons as I've outlined. But now when it's going to come to an end, we are allowed to use the very conferral of the rights that were always limited in time, and for a particular purpose, we're allowed to use that to say, well, having given us these rights, you can't take them away, because this is going to limit our rights and affront our, and in so doing affront our dignity or affect or breach our dignity rights. With respect, that is not a cognizable argument. It's not a legally tenable argument. It's not legally tenable because it utilizes something that was given for a particular purpose, and temporarily it utilizes to extract rights which the scheme never intended to give and did not give. And that, we submit, is fundamentally incorrect, wrong, and no legal basis for that has been advanced. The second reason it can't do that is because on a proper construction, as we've outlined this morning, the minister's decision does not take away rights at all. The rights, if you want to talk about taking them away, and we submit that's the wrong construct, they're not taken away, but the rights end when the ZEP ends at the end of 2021. That's when the rights ended. They were given for a particular period. They came to an end at a particular period. The government deciding to not renew and grant a further blanket exemption doesn't take away any rights. It simply doesn't take away rights. It doesn't give new rights. It doesn't give a fourth exemption regime, but that's not the same as taking away rights. And just as I submitted this morning, no one could compel the government to ever have a 31(2)(b) exemption regime in the first place. You can't compel the government to have a fourth exemption regime where it decides for policy reasons not to. So we submit that the limitation of dignity argument doesn't get off the ground. The rights are limited, if they are limited at all, they are limited, Justices, by, as I've said, the terms of the ZEP itself, but also they're limited by the Immigration Act, because the Immigration Act only permits, as does such legislation throughout the world, only allows persons who are not citizens to be in a country for whatever purpose in terms of that legislation. And absent a challenge to a particular provision of the legislation, you must comply with the legislation. So to ask Zimbabweans who are no longer the beneficiaries of the discretionary exemption regime to comply with the Immigration Act as does everyone else, as everyone else must comply, cannot possibly affront their dignity. And it's an argument which is simply untenable if you unpack it. So we say that absent a constitutional challenge, the Immigration Act applies to everyone. And if you are unhappy with any particular aspect of the Immigration Act, you must challenge it for its constitutionality. That was, for instance, done in Raymond. The Raymond case, which is a judgment of Judge Sher in this division, sorry, not in this division, in the Western Cape division. And we've uploaded it on case lines. The court will find it at 62, I'm told, 062-1. I don't ask the court, sorry, 62-1. We uploaded it, Justice, and I don't ask the court to go there now, but just very briefly in Raymond, spousal visas, which were issued in terms of Section 18 of the Immigration Act, the section and the regulations were challenged because spousal visas in terms of the Act and the regulations came to an end if the spousal relationship came to an end. And the applicants in Raymond challenged it on the basis that those individuals who came to court were all persons who had spousal relations with South African citizens or permanent residents and had children as a result of those relationships. And given that their spousal visas came to an end, they no longer were...
Considered video.
I'm sorry, Justice.
Sorry, I don't know, somebody else is speaking. I don't know who it is.
Apologies, my lady. It's Mr. Mpanana, but I've muted him.
Sorry, Justice. So the recipients of those spousal visas could no longer stay here in terms of the spousal visas because those visas had come to an end, or because the spousal relationship which underpinned the visas came to an end. And they said that that decision was unconstitutional, or that result was unconstitutional, and the act that permitted it was unconstitutional because it paid no attention to the fact, to both, they raise a number of rights, dignity rights, rights not to be separated from their South African citizen, permanent resident children, the right to support and cohabit or live with the children, etc. And Judge Sher in the Western Cape High Court found that that was a sustainable challenge. So that demonstrates, we submit, the proper manner in which, if you are dissatisfied with the result which the Immigration Act allows for, you challenge it. You challenge its constitutionality. You can't argue that the mere fact that you, as a foreign resident with no other entitlement to be here, have to leave at the end of your entitlement, that's an affront to dignity. That would upend the entire immigration system, and it is not a cognizable argument. The very same goes, Justices, for the argument based on children. That argument that either the government or the minister did not consider the impact on children, or that children have some sort of substantive right which is being limited by that ZEP holders and their children have some substantive right that's being limited by the so-called termination of the exemption regime, we submit cannot be sustained for much of the same reasons that I've advanced already. A right temporarily limited cannot give you rights that were never intended. The cessation of those rights because the permission comes to an end, as the ZEP did at the end of 2021, you can't elevate that fact. You accept the benefit, and when it comes to an end, you say, hang on, because the benefit was given to me, even successively, but each time with a qualification that it gives me no rights other than the benefit itself. I now want a court to give me rights which transcend the benefit. Whether in relation to dignity, children, etc., we submit that cannot fly. There are a succession of cases which we've referred to in our heads, such as Pridwin, that make the point that children are to be valued for themselves and not simply as an adjunct to adults in order to obtain rights or benefits for adults. We submit that principle applies equally with regard to this analysis. But I also would like to refer the court to the Grootboom judgment. The reference is 2001-146 Constitutional Court at paragraph 71, where the court there, justices, made the point that has been repeated elsewhere, that the rights of children cannot, well, let me read the passage to you. It was in respect of an argument advanced in Grootboom, and there were two bases, or there were two legs to the argument in Grootboom, one based on section 26 and one based on children's rights under section 28. And apropos of the section 28 argument, the court at para 71 of Grootboom responded by saying the reasoning produces an anomalous result. People who have children have a direct and enforceable right to housing. This is paraphrasing the argument under section 28(1)(c), while others who have none, or whose children are adults, are not entitled to housing under that section, no matter how old, disabled, or otherwise deserving they may be. The carefully constructed constitutional scheme for progressive realization of socioeconomic rights would make little sense if it could be trumped in every case by the rights of children to get shelter from the state on demand. Moreover, there's an obvious danger. Children could become stepping stones to housing for their parents instead of being valued for who they are. And we rely on both those propositions, Justice. The second one I've already alluded to, but the first one is that rights of children cannot trump, in this case, a carefully constructed statutory scheme, which itself is based on the constitutional distinction between citizens and non-citizens, and which is not challenged in this matter. With regard to the impact on children, the third ground of the attack by our learned friends on the decision, we've largely dealt with that in my submissions above. The impact, the fact that there would be an impact on ZEP holders, including children, and indeed other vulnerable groups such as the elderly, etc., was clearly a factor that the minister took into account. The answering affidavits on the part of the department say so. But more importantly, with regard to impact, on our analysis of the minister's decision, and I've made that submission, I'm not going to repeat it, the impact on the 178,000 multiplied by however many people are in each household could not sensibly and was not legally required to be assessed before the policy decision was announced. It can only sensibly be considered and weight attached to each individual attention given to each application for waiver or otherwise when those are made. And that is the constitutionally appropriate time to consider impact. It's entirely within the requirements of the Act, and it's also a rational manner of proceeding. And it gives effect, it means that you have individual, particularized attention to individual circumstances. And we submit there can be nothing to be complained of in that regard. The final aspect
Mr. Jamie, I'm concerned about your time.
I'm now to.
It's already now half an hour since we commenced, and you're not done yet with your argument.
I have
so
one.
I'm really concerned about it. You said you still want to deal with the correspondence to Scalabrini. That's before Advocate Rosenberg addresses the court. Can you indicate to the court how long you're still going to be?
Less than 5 minutes.
Okay. Thank you.
The last aspect is the Scalabrini correspondence. And really, I'm going to be brief in this regard, Justice. It is to be found at 10 case lines 10.377. Could I ask the court whether you have that, Justices?
Going there now.
Court, please.
Is it SA6A? Don't know.
It is indeed so, Justice.
Thank you.
As the court pleases. Justices, we refer to this correspondence for a number of reasons. One of them being it's a recurring theme in especially HSF's heads of argument in their case, that the minister had turned his face against any further exemptions, and thus this entire solicitation or eliciting of further comments and applications was, if not a charade, was not to be taken seriously. We submit that that is not correct. I've referred you to the facts in that regard, to the setting up of the committee, to a special task team. You'll be aware of that. But this correspondence sheds light on that, and it's necessary to refer to it for that purpose, which I'm going to do. But then there are at least two further reasons I want to refer to it. The second reason, Justices, is to indicate how a particular member of civil society, namely Scalabrini, interacted with the department subsequent to the announcement of the decision. And we submit that the way in which it did so was a sensible way. It had enough information, and clearly it took up the opportunity to interact with the department and to attempt to work together with the department in a collaborative effort in order to assist Zimbabweans affected by the decision. So that's the second reason we refer to it. And the third reason is just to demonstrate the number of, or the fact that there were ongoing applications coming in and the minister's references to that. So those are the three purposes of referring to this correspondence. Can I take the court to, can I begin with the first? Because the minister's response to this is repeatedly referred to in the heads and the papers of HSF. So they repeatedly refer, Justices, in support of their contention that the minister will not grant any further extensions to what you find at page 10-393, paragraph 47. And if I can ask the court to go to that, 10-393, but they only refer to the first sentence of that. And they emphasize in their heads or the papers, or both, the word anymore. So the minister there says, this is a letter, by the way, from the minister, as you see at the bottom of that page, to Scalabrini. I do not intend to grant exemptions in terms of section 31(2)(b anymore. And that's where they stop in there, and they never quote the second sentence in that paragraph. They only quote the first and they underline the word anymore. Now that's in response, Justices, to a question which Scalabrini posed at page 10-382. Three paragraphs at 382, where under the heading recourse to section 31(2)(b and c, the questions are posed, the following is stated. To the extent that any ZEP holder is not able to obtain any of the mainstream visas under the Immigration Act, that person would be entitled to apply for an exemption in terms of section 31(2)(b or a waiver in terms of section 32(1)(c of the Immigration Act. In practice, we are aware that such applications take considerable time to be finalized. Kindly confirm that ZEP holders may apply for such exemptions or waivers, and if so, whether their ZEPs will be extended pending the final determination of those applications. So that's the question that's asked. Can they apply for exemptions in terms of 31(2)(b) or waivers in terms of C? And the Act allows for waivers in terms of 31(2)(c). The answer of the Minister that I've just read to you, Justices, at paragraph 47.393 is the following. I do not intend to grant exemptions in terms of 31(2)(b) anymore. However, waiver applications are being considered. Now, with the greatest of respect to our learned friends for the applicants, it's not correct. I don't want to use the word misleading, but it's simply not correct to stop there and to not refer to the fact that the Minister is considering waiver applications. And this is not a one-line statement, because can I take the court to the Minister's answer? Can I begin at 386, Justices, and just run through the references to waiver in this document? The Minister at para 9 says, it is upon this basis that some of the affected Zimbabwean nationals have already applied for waivers. The DHA has already received 1,409 applications for waivers of some of the requirements. Para 10, I've already indicated that the Zimbabwean nationals have already applied for waivers of one or other requirement. Para 19 on 388. The DHA has received applications for general work visa, critical skills visa, business visa, relatives visa, and spousal visa. This list is not exhaustive in the sense that many applications are being received from VFS Global. Para 32 on page 390. I've already indicated that the DHA has already received waiver applications. And then 35, each and every applicant who applies for business visa has to comply with the relevant regulations. I've already indicated that those who do not meet all the requirements have an option to apply for waivers. In fact, some of them have already done so. And then lastly, 45, each and every application, including waivers, would be considered their own merits. Moreover, the decision taken by DHA must be lawful. Now, in the light of that, with the greatest of respect, Justices, it's not possible on these papers to say either that this is a chimera and not a genuine opportunity, or that such applications have not been received. The last point I want to make based on this correspondence, and I've already referred to that, is the spirit of cooperation that appears from this. The papers indicate that this interaction between Scalabrini and the department was not at the department's invitation, but Scalabrini initiated an interaction, requested a meeting. That meeting is adverted to at para 1 of the letter from Scalabrini at page 10-377. There was a meeting, I believe a virtual meeting, on 18 February 2022. Submissions and comments were made. Para 2, in particular, we welcome your willingness to discuss the plight of holders of ZEPs in the light of the decision taken by the department not to further extend those permits, etc. And then they seek clarification, and there's a question and answer, or a series of questions raised. It's clear from the Minister's response that those questions were taken seriously, and the Minister's response. There was absolutely no other parties or members of civil society who considered themselves interested enough to litigate against the department did not take up a similar or seek a similar make representations. Those are our submissions, Justices. I'm very sorry to have taken up more than my fair share of time. We submit for those reasons that the applications of COMSA and HSF should be dismissed. In light of Bar Watch, we obviously don't see costs. We'll address you on remedy, Justices, once we fully have HSF's order that they seek in that regard. Unless there are any questions, sorry. Unless there are any questions.
Thank you, Mr. Jamie. I just wanted to invite you to upload your note for us that you made reference to. at the commencement of your argument, and if you could do so by no later than this coming Friday.
I will try my best to do that, Justice.
Okay, thank you. Any questions on the side of Judge Malindi?
Thank you, my sister. No questions.
Thank you, Judge Mota.
No questions. Thank you, my sister.
Right. Thank you, Mr. Jamie. Then it's Advocate Rosenberg.
As the court pleases.
Thank you, Justice. Thank you, Justices. I'm going to deal with the application by, or the counter application by the third respondent, Adfarsa. And I'm going to do so by first addressing the question of the delay as raised in the opposing affidavits, and thereafter I'm going to deal to the extent necessary with the merits of the counter application. As to the delay points, the decision to grant the ZEPs, as we know, was taken in September 2017, and equally we know that the 12-month extension of the ZEPs was granted in September 2021, with the subsequent 6-month extension granted in September 2022. The present application to intervene was launched on the 27th of September 2022, and the affidavit which served as the founding affidavit in the counter application was launched, delivered on the 27th of February 2023. So effectively one is dealing with a delay of some 5 to 6 years, depending upon exactly when one reckons it up to, from the time of the critical decision, which is the subject of the attack in the counter application. The nature of the counter application is an application for, in the first instance, declaratory relief in terms of section 172(1)(a) of the Constitution, accompanied by, in paragraphs as formulated in paragraphs 6.12.2 of Adfarsa's heads, with what is contended to be an appropriate remedy, deeming the ZEPs to be valid for a period of 18 months that was subsequently revised. The nature of that remedial relief is such that it's obviously predicated, as it must be, on the decision that the subject of the declaratory order, the decisions being set aside. Although it's not expressly claimed, it necessarily follows from the remedial relief that is sought in the form of deeming the ZEPs to be valid, and that follows necessarily from a proper appreciation of the Odekral principle. The Odekral case has been referred to in the heads of argument. I think it was of the first applicant at the time the intervention application was opposed. It's 2004 6 SA 222 SCA, and effectively the proper import of the Odekral principle is that the impugned decisions remain effectual until properly set aside. And so effectively recognizing that principle, one must accept that the attack in the form of the declarator and the section 172 1B remedial relief is predicated on a setting aside of the decisions. If one is then to accept, as for example, the first applicant does, that the attack on the decision, in fact, the attacks on any of the decisions in this matter are effectively attacks to be considered in the context of a PAJA review. Alternatively, if one accepts that the attack is properly to be construed as a legality review, one comes to much the same outcome as far as the question of the delay is concerned. There are certain minor differences which are not of particular significance in the context of this matter. If one accepts that this is a PAJA challenge, as we've set out in paragraph 13 of our heads, and the first and the second respondent heads of argument in the counter application is to be found in case lines at item 6.5. I think it's in fact one of the early, it's found its way into an early item on case lines. It's 6.5. As set out in paragraph 13 of our heads, in the context of PAJA and the 180-day period as constituting the outer limit of what is a reasonable period, where the application is launched outside that deemed unreasonable period of 180 days, an application for extension, of course, is required in terms of section 9.1 of PAJA, and we've referred in footnote 11 to the SCA decisions in Mostert, as well as the Sasol Chevron case in support of the general proposition, and it's subject to certain exceptions which are not necessary for us to go into at this stage, the general proposition that where no application for an extension of the 180-day period in terms of 9.2 is made, the court has no authority to enter into the substantive merits of the review application brought in terms of PAJA outside the 180 days. We make the point
that's where I have a problem. That's where I have a problem, Counsel, with your argument.
I can't hear you. I think you're on mute.
No, I'm not. As much as I think Justice Collin was also not on mute. I'm sure she was trying to shout out.
Yes, Justice Motta, we can't hear you down in Cape Town.
Can you hear me?
That's also my challenge. I'm asking a question and I can't. It seems like Mr. Rosenberg is not hearing us. Are you hearing us, Mr. Rosenberg?
Sorry, Justice Motta, we've regularized the position. My apologies for that.
Can you hear us?
I can hear you, Justice Collis. Thank you. Sorry, right. Justice Motta.
I asked an earlier question and you didn't seem to respond.
Yes, my apologies for that. That was a technical shortcoming.
Okay. I think you can proceed, Judge Motta.
All right. Can you hear me now?
Yes, I can, Justice Motta.
Yes. I'm referring to your reference of PAJA, yes, because it seems that's an attack you launch against the truckers case, that it is outside the period of 180 days, correct?
Justice Motta, the point that is made is, depending upon the court's approach to the proper categorization of the challenge, we're dealing with an unreasonable delay. If the court were to find that the challenge is properly a PAJA challenge, then the provisions of Section 9 would come into play. But the submission is if the court alternatively were to uphold the contention that the challenge is properly to be construed as a legality challenge, the Kamala approach to delay fines
the
application.
two-test
Yes.
approach of Khumalo, unreasonableness and undue delay.
Yes.
I would have expected to see the Khumalo test in your attack of the truckers if you were entirely basing your argument, as we've just listened to almost 3 hours of an argument saying that this is not an administrative decision, but you seem to attack the truckers on Baja and thereby giving an impression that Baja is applicable under these circumstances.
Yes, Justice Motta, the approaches indicated in our heads is whether you approach it in terms of a Baja delay or whether you approach it on the basis of a legality review on the application of Khumalo, and both those approaches are dealt with in our heads. So for present purpose...
I was referring to your answering affidavit, to the supplementary affidavit of the third respondent. I think it's on 055-1 of the case lines, and it's at paragraph 11.
Yes.
In your affidavit, it is as clear as daylight that the attack is on Baja, and thereby giving an obvious impression that you are alive to the fact that Baja could be applicable or is applicable. Hence, your attack is to use 180 days.
Yes,
Khumalo is not even mentioned there.
Yes, for present purposes, though, in considering the trucker's application and the question of delay, it's necessary to present the submissions upon the basis of either Baja being of application or, in fact, a legality review with the concomitant Khumalo test being of application. For the purposes of these submissions, I'm adopting an agnostic approach.
I understand that, but I'm just saying in your answering affidavit, Khumalo, in terms of a principle of legality, which is that two-stage test, is not even contemplated. The attack is solely on Baja. And this ties in with what your opponent said. It was almost a belated thought that there should be a reliance only on principle of legality, and Baja should be attacked at all costs.
Yes. Justice Motta, I entirely accept that observation or that remark, but the submission is that in the context of what is presently under consideration, one is determining the question of delay.
Yes,
and
yes, no, you're right. I mean, I fully agree with you. Both sections are dealing with delay. Your Khumalo test looks at delay as well.
Yes,
you're right. Okay.
Can I
won't pursue the point any further. I think I won't belabor the point. The point is made. We can move on.
Yes. So accepting whether, in fact, one is approaching this through the lens of Baja or through the lens of Khumalo. If one is approaching it through the lens of Baja, the question of delay, well, then we make the point in paragraph 13 of our heads that I've adverted to, of the necessity for an application to be made. And in the present matter, we emphasize that although there was a reference in the replying affidavit of the truckers, that the lapse of time was not unreasonable, and that if it were unreasonable, the court should condone it, we would submit that that doesn't meet the contemplated requirement of section 9.1 or 9.2 of Baja, that a properly motivated application for condonation of the failure to comply with the 180-day requirement is to be granted, and setting out full details of the delay. In relation to that particular point, of course, the question of delay was not adverted to at all, as I recall, in the heads of argument of ADFASA for some reason, and no application was moved in front of this court in any cognizable form for condonation in terms of Section 9 of PAJA. So that's the submission in relation to the question of condonation for the delay if one is approaching the matter as a PAJA challenge. If one is approaching the matter as a Khumalo challenge, we would submit that quite clearly the lapse of time is unreasonable, and the question then would be in the exercise of the court's discretion to condone the lapse of time, which we have pointed out is in excess of 5 years. The reasons that were given for the delay is put up in reply at 058-9 is the case line's reference, paras 3.2 to 3.5, and the argument is that ADFASA only came into existence when it was incorporated in 2022, but the court will have observed that it was registered as a not-for-profit organization as early as November 2020, and the court will also have observed that in its founding affidavit, or in fact in its founding affidavit in the intervention application, it traces its members' involvement in the issue of non-South African citizens being employed as truck drivers, and the instability that has caused in the industry back to 2018, where there's reference to a letter from Cowan Harper attorneys, which is at AT3 026-51 of the case lines bundle, where there's a reference to 47 companies apparently being identified, and there is a further reference to the 47 companies identified being the subject of a meeting that was subsequently held, and the meeting is referred to at 84 of the intervention application, and one sees there that in particular at paragraph 25 of that affidavit at 026-14, there's an indication that even at that early stage, ADFASA is referred to, despite the fact that it only formally adopted a constitution in 2022, and the fact that it only formally registered as a non-profit organization. ADFASA's participation in that meeting is referred to, and we see in the report of that meeting, the question of the ZEPs was specifically adverted to. So the point that I wish to emphasize is that if regard is had to the evidence put up by ADFASA as to its involvement and its role in this particular sector, it's quite clear that it was active, and it was in one form or another, and certainly referred to as ADFASA as early as 2018, an involved and important participant in the question of the issues that it now raises in its counter application. So we would submit that in those circumstances, the mere adoption of a constitution and the formal step of constituting ADFASA as a voluntary association with juristic corporate personality really doesn't, in fact, absolve it for us from answering for the delay in question. We have referred in our heads of argument to the approach of the SCA in the Sunroll matter in paragraph 22 of our heads of argument. The case lines referenced is 6.11, where the Supreme Court of Appeal emphasized that it would be anomalous if an administrative act were to be reviewable at the instance of one member of the public and not of another, depending upon the peculiar knowledge of each, and that the court must take a broad view of when the public at large might reasonably be expected to have had knowledge of the action. So the fact that at FASA may not have adopted its constitution until 2022, and the fact that it may not have been registered as an NPO until in November 2020 doesn't effectively give it an out, and for it to assert that its knowledge must be confined to the period as it seeks to do effectively from November 2022. So on those submissions we submit, the period of the delay was plainly unreasonable, and it's a question of, has a basis been set for the court, this court, in the exercise of its discretion to overlook or condone that delay? It might be that if the merits of the case were clear and beyond dispute, to use the language of Buffalo City in a slightly different context, if the merits were effectively or where the impugned decision was indisputably and clearly inconsistent with the Constitution, the court might, of course, then be prepared to, if not obliged, to overlook the delay as far as the issuing of a Section 172(1)A unlawfulness order is concerned. That, of course, doesn't extend to the question of remedy in terms of 172(1)B and whether a setting aside would be appropriate. But we would submit in the present case, we're dealing with an unreasonable delay. We're dealing with a situation where little or no explanation has been put up, satisfactory explanation has been put up on the basis of which the court could conceivably overlook that delay. And it's certainly not a case where the decision, the impugned decision, is indisputably and clearly inconsistent with the Constitution. I'm borrowing those words from paragraph 71 of the Buffalo City decision, which we have referenced in our heads.
Mr. Rosenberg, you only have another 15 minutes left.
Yes,
so I think you must keep that in mind.
I'm going to now move on to the extent necessary with the question of the merits, because the merits are relevant to the question of the exercise of the court's discretion to overlook an unreasonable delay. In our submission, the merits are poor, and I'm going to deal with them very briefly because, with great respect, I don't think they require more detailed treatment at this stage. We've dealt with them in our heads. If I could first deal with the challenge based upon the contention that the exercise of the power to grant a Section 31(2)B exemption does not extend to granting that exemption in respect of illegal foreigners. That argument was based exclusively in the written submissions that were made yesterday on a definition of foreigners. on the definition of foreigners. Well, with respect, the argument fatally, or the reference to the definition fatally undercuts the argument. It operates in exactly the opposite way that it was contended on behalf of the truckers it should operate. The definition of foreigners is broad, and as we know, it effectively includes or refers to all, if I could just find the definition for you quickly, it refers to an individual who is not a citizen. That definition puts the point to rest, because illegal foreigners are effectively a subset of foreigners. And there's no reason why one should approach the reference in section 31 2B to foreigners as impliedly
Are you still there, Mr. Rosenberg?
has everyone been kicked out.
Sorry, Mr. Rosenberg, are you still there? Sorry, Judge Mota,
Seems to
can
be
you still hear me?
frozen.
He seems to have frozen.
Can you still hear me, Judge Mota?
Yes, yes, I can certainly hear you. Can you hear me?
Yes, Judge Malindi, are you still there?
I'm still here. Mr. Rosenberg did indicate that he's been kicked out. Maybe he will reconnect.
All right. Give him a minute or so. Depo, just admit Advocate Rosenberg again.
I will do so, my lady.
Thank you.
My lady, I've just received a WhatsApp from Mr. Rosenberg's Jr., who's indicated that there's a problem with their Wi-Fi. They are trying to fix it.
Okay. So,
Thank you, my lady.
Depo, you'll let us know when he's back online.
Yes,
I'm just going
I
to
will
take
do
my
so.
camera off.
I will do so, Judge.
Okay.
Justices, can you hear me?
Yes, thank you, Mr. Rosenberg.
Justice Collis, can you hear me?
Yes, thank you, I can.
We've had to make some backup arrangements because our Wi-Fi facility failed, but we've made an alternative arrangement. And if I could just continue through as briskly as I may to the end of the argument. I was dealing with the question of what we described as the poor merits of the challenge. I dealt with the illegal foreigners argument, and I've made the point that if reference is had to the definition of foreigners, which was the basis of the argument based on behalf of the third respondent yesterday, that the definition of foreigners undercuts the argument that is made. Foreigners is an inclusive term, whether those are illegal foreigners or not. The very purpose of the power in terms of Section 31 2B to grant exceptions and the protective power that creates is to provide appropriate protection and a solution in circumstances which are qualify as special circumstances in respect of foreigners. There's no reason why the exemption powers should be excluded from unlawful foreigners or illegal foreigners. One knows that there are specific provisions in the Act which would be of application in the case of illegal. Section 32 of the Act, as read with Regulation 30, which may appropriately, and particularly in specific or unusual circumstances, require the exercise of the power to exempt the foreigners concerned from compliance with those provisions. So there's absolutely no reason to employ or adopt a narrow construction at odds with the definition of the reach of foreigners in the context of Section 31 2B. As far as the question of Zimbabwean nationals are concerned, I didn't understand that argument to be persisted with yesterday in the submissions made, and we would submit that that's rightly so, inasmuch as the Section 32 1B power permits the exemption to be granted not only in respect of particular individuals, but in respect of categories of persons, and in those circumstances why the categories of persons in question should exclude unlawful, or should exclude, in this case, unlawful or illegal foreigners who happen to be Zimbabwean illegal foreigners, is not at all clear. The wording of Section 31 2B and its specific reference to categories as being a permissible manner of the granting of exemptions with respect puts paid to that argument, and we would submit that it rightly appears to have been abandoned in oral argument yesterday. As far as the absence or otherwise of special circumstances is concerned, the court will be aware from the evidence generally and the in particular, for example, the reasons that were given by the responsible ministers in 2014 and 2017 for the ZSP and ZEP regimes, and those press releases providing the context and reasons for the decision taken appears as FA2 and FA5, that's Minister Gigaba and Minister Mkize's explanations for the regimes being established at that stage, indicate with respect quite clearly special circumstances, and nobody has sought to challenge the existence of special circumstances at that stage. The argument that was presented to you yesterday was again a much more confined argument, And it appears to be along the lines that given one of the reasons advanced for those regimes was capacity constraints of Home Affairs asylum seeker management systems, that could never constitute a special circumstance. The argument was that particular problem was one which was appropriately to be addressed in terms of the Refugees Act, and that being so, there was no power to grant the exemption concerned. With great respect, there's no reason to construe special circumstances as excluding the capacity challenges and constraints faced by the department in dealing with illegal foreigners. A component of that particular illegal Zimbabwean foreigners, a component of that cohort being asylum seekers, merely because effectively that particular component of the cohort, if it were to be dealt with according to the applicable legislative scheme, would be dealt with in terms of the provisions of the Refugees Act. The fact of the matter is that there were significant constraints in dealing with the entire cohort of illegal Zimbabwean foreigners, including potential asylum seekers, and this was a device for the reasons indicated, attempting to deal with, amongst other things, capacity constraints, and hence exempting the illegal foreigners in question from, amongst other things, the provisions of Section 32 of the Immigration Act. So we would submit that there's no basis for asserting that special circumstances which justify the utilization of the power can never include restraints on, for example, the asylum seeking management system. So we submit that that argument must necessarily fail. The next challenge goes to the contention that the Section 32(1)(b) power is predicated upon effectively a substantive jurisdictional requirement, not only of special circumstances, but the necessity that it can only be exercised in the context of an application being made. The application argument appears to us to elevate what is just a procedural, what is clearly just a procedural requirement, into a substantive jurisdictional precondition for the exercise of the power. This is a procedural requirement, and in each case, one must consider whether, in fact, there has been substantial requirement, compliance with that requirement. Of course, the short answer in our submission is that in this case, for each of the permits that were issued for the 178,000 plus ZEP permit holders, there were, of course, applications. And those applications were granted. And that would appear to us to be the complete answer to that particular contention as to the so-called procedural requirement. The final point is that absent empowering provisions in the Act to extend the permits, the minister couldn't do so. That was initially presented on the basis, as I understand it, that there could be no extension after the lapse of the permit or the expiry of the permits, when in fact it became clear that the extensions were granted, the extension was granted prior to the lapse of the permits in question. The contention was persisted with on the basis that whether before or after the expiry of the permit, there's no power on the behalf of the minister to grant that amendment. We submit that the power to extend flows naturally from the minister's power to determine the terms and conditions and period of the exemption permits. It's a necessary adjunct to that power to determine, as we say, in particular, the period of the exemption permit. And if it's not to be construed as an express power in the on a proper construction of Section 31(2)(b), we would say that it's alternatively to be construed as an implied power to achieve the proper purpose of this provision. That would be on the basis of the analysis of implied powers that we see in the Amubangani case, 2021 3 SA 246cc, at paragraph 63. So though we would submit that the challenges are effectively still borne, they certainly don't rise to the level of being, let alone undisputed, and they clearly don't rise to the level of this court being able to conclude in this context that the impugned decision of 2017 was clearly inconsistent with the Constitution. For those reasons, we would submit the application, the counter application should be dismissed with costs. The observation in relation to remedy is a confined observation, and we are taking further instructions in the light of the adjustment of the remedy sought, where the 18-month period that was provided for, just bear with me, the 18-month period that's provided for in paragraph 612(2) of the third respondent's head has been revised down to 12 months. We do, however, make the submission that, as you have heard, the ZEPs expired by a fraction of time on the 31st of December, or due to expire by a fraction of time on the 31st of December 2021. A 12-month extension was granted for the purposes that have been dealt with elsewhere. A further 18-month extension was granted. So as far as the minister is concerned, a further 6 months, sorry. So as far as the minister is concerned, upon expiry, the originally provided for expiry date of the ZEPs, a period of 18 months has been granted specifically for the reasons adverted to in the submissions dealt by counsel for the minister in dealing with the HSF application. And in those circumstances, as a matter of principle, any further period that were to be granted in the context of a setting aside of the 2017 decision and the subsequent extensions should take into account the purpose and the nature and purpose of the extensions which have been granted. And the upshot of that would be...
That point has already been made by Mr. Jamie. I think he's alluded before to that. You don't have to repeat it. Is there anything else on your argument, please? Because we're really out of time now.
Those are the submissions in relation to the counter application. We should submit it falls to be dismissed.
Thank you. Thank you, Mr. Rosenberg. Any questions, Mr. Rosenberg, Judge Malindi?
No questions until we receive a refined draft order. Thank you, my sister.
Thank you. Judge Mota?
No, mine have already been addressed.
Thank you. Thank you, Mr.
Thank
Rosenberg.
you, Justices.
Is that bringing us now to the reply?
Mm-hmm.
It is, my lady.
Okay. perhaps indicate to the court how much time do you require?
Yes, my lady,
know
I had in chief indicated that I would need 30 minutes or 45 if I was dealing with the truckers. The good news is that I'm not dealing with the truckers. I think they've been dealt with comprehensively. And Mr. Simmons and I had each indicated half an hour. We will make sure we finish within an hour between us. But he has generously agreed that if I need a few of his minutes, he will give them to me. So I'm going to try and be done in half an hour. But if I need 5 more minutes, he's donating them to me.
So between the two of you, you'll take an hour.
An hour, my lady. We'll be as brief as we can, but you'll appreciate there's quite a lot to deal with.
No, I understand that. The challenge is just, I have already moved another meeting that had to be in after hours. I've moved that meeting to 5.
Yes.
And you would recall that I asked yesterday, is there a need to start earlier on? And the decision was no, we should
Yes.
start at 10.
Yes.
Now, this is now the result of it. I cannot move that meeting again. I've already moved it.
Well,
It was to commence,
my lady, could I ask this? Would it be, we were all reserved for tomorrow. Would it be convenient if we did the replies tomorrow morning or finish the replies tomorrow morning and just start the ZIF matter, if that's convenient? But I'm in your hands, my lady.
Look, I don't know whether that's going to not impede on the time allocated for that matter, because we might just sit way beyond tomorrow for the matter reserved for tomorrow.
Well, my lady, I'll be as brief as I can. But my suggestion is we should start and see how we go.
Yeah, the point I'm making is I will not be able to deal with this matter beyond 4:30, unfortunately. I had another meeting scheduled, and I've already shifted that meeting to commence at 5.
I understand, my lady.
Okay. So let's start with your reply, Mr. Butler. Thank you.
Thank you, my lady. My lady, I wish to make 5 points in the reply, and we, of course, disagree with much of what's been said, but we want to focus on the critical issues. Firstly, I want to deal with why, on my learned friend Mr. Jamie's argument, on his own argument, the minister's decision is plainly unlawful. Secondly, I will deal briefly with the Pudger debate. Thirdly, I will deal with the ground of review. Thirdly, I will deal with the ground of review that's really not been answered, and that's the failure to consider the adverse impact and the problem of the missing minister's affidavit. Fourthly, I'll deal very briefly with the rights violation. And fifthly, I will just deal briefly with remedy. But let me jump straight into it, my lady, because we heard a lot from my learned friend, Mr. Jamie. And the one thing that is now clear is that I now at least understand his case, or his client's case, even though with respect, I don't accept that it's well-founded. And I want to recount 4 propositions that my learned friend, Mr. Jamie, put out there. And I want to accept them for the moment as all being true, because if they're all true, that is with respect the end of the minister's case. So the first proposition that my learned friend advances is that the decision to end the blanket exemption is policy-based. He says it's about policy. And the second point he makes is that because it's policy-based and therefore beyond Pudger, but the second point he makes is that the decision to end the blanket exemption is subject to the principle of legality. He concedes that, and he concedes that that includes procedural rationality. The third point he makes is that when the minister took the decision to end the blanket exemption, that decision was final, and it will not be reconsidered. And he said that unequivocally. And the fourth point that he made is that there was a call for representations from the 178,000 people, and those call for representations didn't relate to the decision to end the blanket exemption. They only related to whether individuals should be given waiver. Those are 4 propositions he advanced. He advanced them carefully and deliberately. But when you add them all together with great respect, that is the end of his client's case. Because what that demonstrates is that on the decision to end the blanket exemption, there was no representation before the decision was made, and there was no representation after the decision was made, and that was what the minister decided. And so we are left with a position where the Minister of Home Affairs had to decide whether to end the blanket exemption. He took that decision without hearing people before. He took that decision without hearing people afterwards. And that means that there's been a violation of procedural rationality, because there is no explanation as to why that process was considered appropriate. Now, my lady, it couldn't be clearer. I'm assuming all four things in my learned friend's favor, but when you assume them all in his favor, it is absolutely clear that the principle of legality has been violated. And what is equally clear is that if you accept his four propositions, what is equally clear is that the judgment of Scalabrini, and let me say there's a bit of confusion. There are two judgments in Scalabrini. There's Scalabrini 1 and Scalabrini 2. They're both in the bundle, but I am referring to Scalabrini 1. And I must just briefly take the court there because it is on all fours with this case. Could I ask the court to go to Scalabrini 1 at 029-601? I'm sure my junior will direct us there, hopefully with success.
Which paragraph?
A big pardon. I begin at paragraph 58 because what I'm going to demonstrate to you is that this case is on all fours, because in paragraph this the court will recall is the closure of the refugee reception office. And what the court said at paragraph 58 is that the question whether a refugee reception office is necessary for achieving the purpose of the act is quintessentially one of policy. So it says, just like Mr. Jamie says, that says it's quintessentially a policy question. How many officers, blah, 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 blah. That is a policy question. And he therefore says it's not admin action. And at paragraph 60, Justice Nugent then says, but this does not mean the decision is immune from scrutiny by the courts, because it's now axiomatic that all public power must comply with the Constitution, including the doctrine of legality. And then at paragraph 60, at paragraph 67, he summarizes the argument about consultation. And 68, he cites Albert. And 69, he cites DA versus the president. And he says there is a requirement that the process be procedurally rational. And in 70, he says, in this case, the DG, that was the decision maker there, the DG was pertinently aware that there were a number of organizations, including Scalabrini, with long experience and expertise in dealing with asylum seekers that had undertaken to consult. In the absence of any explanation for not having done so, I'm left to infer that the DG's failure to hear what they might have to said was not founded on reason and was arbitrary. Now, my lady, it is on all fours. We know that the minister knew that there were organizations who had an expertise. It's shown by the fact that he later sends things to African Amity and the Zimbabwean organization. We know that this is not just a matter about whether to close an office, but a decision of massive national importance, according to the minister. And yet, on his own version as advanced by his counsel, he didn't hear the NGOs or any individual asylum seekers, any individual ZEP holders. He didn't hear them in advance of the decision to end the blanket exemption, and he didn't hear them after the decision to hear the blanket exemption, because the only way he heard them on his own version was he invited them to make representations on a debate about waiver. Now, that is not a substitute for representations on the overall decision. And that, with respect, is the end of the case, because on his own version, there was an irrational process followed. And let me say, my lady, it might be different if there was an affidavit from the minister saying, the reason I adopted this process and didn't hear them was X, but there is no affidavit. And my learned friend has never explained why there's no affidavit. And in truth, that is the end of the case. Let me briefly sweep up the rest of the points on procedure. Our learned friend makes the point that it's impractical to hear 178,000 people. Well, my lady, it's not pleaded. You can't make that point from the bar or in your heads. It's not pleaded. It's got to be in papers. But secondly, that's exactly what happens via notice and comment procedures all the time. When government publishes regulations about COVID or anything else, government puts out a notice, it goes in the Gazette, it goes in the newspaper, they receive thousands of comments, and they make their decision. It happens all the time. And we know that in this case, there was enough time because you are told by the DG in African Amity, and it's part of these papers because we annexed it to our papers. I'll just give you a reference. You don't need to go there. It's 018-131, 018-131, paragraph 89.3, the DG says that DHA started discussing the feasibility of an exemption being extended in June 2021. And we know the decision is only made 6 months later. So there was plenty of time to do a notice of comment procedure. And the notion that you can't contact 178,000 people is patently bad, because we know that they did. They did. They just did it afterwards. Yes.
Yeah, they did it through electronic mail.
So with all due respect, the suggestion of impracticality is not pleaded and untenable. The only other case that we've been asked to, and that's the end of the legality point. Even if you assume against me that Paja doesn't apply, legality applies as was conceded, and the procedure falls to be upheld. And there was no other answer to the consultation on legality point. The points about deflection of time and all the rest, those were Paja points, which I'll deal with in a moment, but they don't answer the legality point, because the legality point is not about rights. It's not about vested rights. It's about all public power has to be rational, and there has to be a rational process. Just as in Scalabrini, there weren't people with vested rights to apply at the Cape Town Refugee Reception Office. They had no vested rights, and yet it was set aside on the basis of procedural irrationality. What that means, my lady, is that your ladyship and her colleagues can ignore the question of Paja and safely decide the point on legality. But just let me round off the Paja, because I don't want you to think that I'm walking away from Paja. Not at all. It's just that the way that my learned friend argued the case made clear that legality was sufficient. So now we come to Paja. On Paja, and that's my second topic, on Paja, there is no explanation at all for the last minute change. And His Lordship, Mr. Justice Motta, asked about the fact that there seems to be a contradiction in the stance. And of course, that it was a last minute change, because until Monday afternoon, there was no suggestion that Paja didn't apply, and you've had no explanation. But of course, we accept people can change their legal points. The problem with it is that the premise of the argument is this was a cabinet decision based on policy. That's the argument that you had advanced again and again. But it wasn't a cabinet decision with respect. How do we know it wasn't a cabinet decision? Because that's what the DG said in the African amity matter. I'll give you a reference again. It's next to our papers, 018-134, paragraph 90.10, where the DG says, the African amity say it's a cabinet decision, etc., and the DG responds vigorously saying, don't be ridiculous, it's not a cabinet decision. It was my decision which got tabled in the cabinet for its information. The other reason that it's bad is that we accept, as Scalabrini held, that policy or the role of policy is a relevant consideration to whether it's admin action or not. We get that. But the idea that you can draw a bright line in the way that my learned friend does is patently bad in law, because what we have here is policy being translated into law. Policy being translated into law by means of a binding decision of the minister. And that is admin action, because the SCA has told us so. It told us so in the Esau case, which was about the COVID regulations, where Judge Plaskett in some detail explained, of course, there were policy decisions from the NCCC underlying the regs. But when the regs are made, in this case, when the decision is taken to terminate, when the regs are made, that policy is translated into law, it has a binding effect, and that then triggers Paja. That is Esau, and I'll give you the reference. It's 029-407, paragraphs 44 to 50. And it really makes the point very neatly, indeed, on the fair hearing point. And ultimately on Paja, our learned friend says it didn't take away rights. Well, my lady, we can debate whether it took away rights. But at the very least, what it did is it affected rights, because the decision affected people's rights to stay in this country. And we now know, and our law has been the case, this has been the case for more than 20 years, that when Paja says a decision has to adversely affect rights, that doesn't mean adversely in the sense of prejudicially. It's been clear since Justice Nugent's judgment in Gray's Marine in the SCA that it just means it has the capacity to affect legal rights. And that's been cited with approval repeatedly. You will find Gray's Marine, we've uploaded it for you. It's at the relevant passage is at page 060-379, paragraph 23. And it has very recently been endorsed by the Constitutional Court in ESCOM. It's the ESCOM case. We've uploaded that for you too. It's 359, paragraph 280, and paragraph 288. Now, in Eskom, what had happened was this. Eskom had reduced bulk electricity supply to various municipalities, and people living in those municipalities had reviewed that decision and had got an interim interdict. And Judge Unterholter, for the minority, said, but there's no right to electricity in that way, and so you can't say that your rights are affected, so you can't say Paja applies. And Justice Madlanga rather, bluntly, made clear that that was not so. And he explained, it's not a debate about whether you've got a right to electricity. It's a debate about whether the decision about bulk electricity affected your other rights. And if the decision about bulk electricity means there's sewage flowing into your rivers, and if the decision about bulk electricity affects the way you live, then your rights are affected and you had a right to be heard. And he says so expressly at paragraphs 280 and 288. So the debate here is not whether the ZEP holders had a right to live here beyond the expiry date. The debate is whether the decision that was, or that they had a right to an extension. It is that when a decision is taken which affects their rights, then they have a right to be heard under Paja. Does this decision affect their rights? Well, of course it does. It affects whether they can stay in South Africa. It affects whether they can work, whether they can earn a living, whether they can go to school. It affects all of those things. And so that doesn't mean it's unlawful by itself, but it means they have to be heard, just as in Eskom, paragraphs 280 to 288, the court made the point. And that is why our learned friend's argument that it didn't take away rights is simply besides the point. Very lastly, on Paja, our learned friend makes the point about effluxion of time, and he tries to answer the cases that we referred to, the two Minister of Defense cases, but with respect, his answer doesn't assist him. He's right that in those cases, what you had was an automatic expiry coupled with an ability of the minister to change that automatic expiry. And what the court said is where there's an ability to change the automatic expiry, then you must consider that and Paja kicks in. But that's exactly where we are here, because everybody accepts, except the truckers, everybody accepts that the minister has the power to extend the granting of this period. And indeed, our learned friend, Mr. Rosenberg, argued that expressly a few moments ago, quite fairly and quite rightly. So we are exactly in those two Minister of Defense cases that we cited, Tulu and I can't remember the other one's name, but we are exactly there because we have a regime which allows for an automatic expiry, but also allows the minister to step in and prevent the automatic expiry. And that was exactly what happened in the Tulu case and the other case we refer to in our note.
Maseki.
I beg your pardon. Thank you very much. I was waiting for a note from my junior, but I'm afraid your lordship is too fast for my junior. Yes, indeed. Thank you. So where are we, if I can just pause? Where we are is that there are two routes open to the same conclusion. One is that this is executive action. It falls to be set aside on the plain authority of Scalabrini because there was an irrational process, and on the argument advanced by our learned friend, Mr. Jamie himself. The second route is that it's not executive action, it's admin action, and then it falls to be set aside in terms of Paja, because the hearing, because on my learned friend's own proposition, there was no hearing after the event. All of this discussion about hearing after the event disappears when my learned friend accepts expressly that there was no hearing after the event on the critical decision. And the critical decision was the decision to end the blanket exemption. So we had to debate pages and pages about hearing after the events, but my learned friend now accepts that there was no hearing after the event on the critical decision. And that critical decision is the foundation. And it's no answer to say, well, we let people tell us whether they want a waiver. That doesn't solve the problem. That's not procedural fairness, because it's not a hearing on the critical decision. So we at least now understand our learned friend's argument, but with respect, it is destructive, both under legality and Paja. And on that ground alone, procedural rationality or procedural fairness, the application must succeed. Moving then to the next ground of review, that's my third topic, and that's the failure to consider the adverse impact. Now, you will recall that the argument is this, and it's necessary to restate it. The argument is that when the minister took the decision, the minister failed to consider the adverse impact on ZEP holders and their children. It's a relevant considerations point. We're not debating whether that point trumps or that point's absolute. It's a relevant considerations point. And the answer of our learned friend, and I wrote it down, he did it just before he ended. He said, the fact that that would be, the fact is that would be that impact was clearly a factor that the minister took into account. The answering affidavits say so. That's his submission. You should conclude that it was taken into account because the answering affidavits say so. But there is no answering affidavit from the minister. There is no confirmatory affidavit from the minister. And we have referred you to the two judgments which make clear that one person cannot make an affidavit on behalf of another to demonstrate what their area of expertise, to demonstrate what their personal knowledge is. And so the DG has no idea whether this was taken into account by the minister. Well, that's the end of the point. And that it's the end of the point is made clear by the Ultron judgment, which we've also uploaded. Again, you don't need to go there. It's a judgment by Justice Lamont where exactly this happened. The minister didn't depose to an affidavit. And Judge Lamont says, well, I don't know what your reasons were because you didn't depose to an affidavit. And that's at page 060-393, paragraphs 26 to 31. And it merely applies the cases which we've already referred to and which have been unanswered. Gerhardt, the judgment of Judge Goldstone, and Tantouche, the judgment of Judge Murphy. And it says that that's it. So that's, with respect, the end of that point. And there was no answer to our submission that when you look at what was placed in front of the minister, the submissions from the DG, you look at the reasons, there's no reference to the impact. And so our learned friend says, no, don't worry, the impact was taken into account because we allowed people to apply for waivers and make representations. And look at how many people did. And yet we sit here with no evidence that a single person has been granted a waiver, no evidence that a single person has succeeded in their representations. None. Now, when I made that submission to you yesterday, I did it anxiously because I was sure that evidence would be around the corner that someone, somewhere had succeeded. Well, there's none. And that's in the face of an organ of state like the Minister of Home Affairs, who has a duty of candor to this court, as I explained yesterday. So was there any failure to consider the adverse impact? No, because there's no affidavit saying so. And the point was raised squarely in our founding affidavit, as I demonstrated to you yesterday. And secondly, no, because the documents that were placed in front of the minister and the documents that emanated from the minister's office, we don't know whether the minister approved those because he didn't tell us, but those documents contain no reference to the adverse impact. So even if you somehow concluded that this was a fair procedure, on this ground alone, the decision has to be set aside because a failure to take account of relevant considerations in this way patently justifies the setting aside under Pudger and under the principle of legality in light of the DA versus the president case, the Similani case. The fourth topic, and the fourth of five, the rights violations. Well, with respect, the debate is really not advanced because our learned friend says our argument means that you can never take it away and that we're claiming that it be kept in perpetuity. That's of course not what we said. We were quite express in arguing that that was not the case. All we said is that when you take a decision like this in respect of people affected, then what you do is you affect their rights adversely such that there's a limitation and it has to be justified. And the problem here is not a debate about limitation. The problem is that the government has not justified it properly. That's the reason that there's a difficulty. And again, we would say to you, we really can't do better than having a look at ESCOM at paragraphs 280 and 284. I gave you the reference earlier. It demonstrates very neatly that you don't view rights just by saying, is there a right to electricity or isn't there? You say, what is the impact of this decision on rights? And the impact of this decision on rights is, as I've indicated, that people will not be able to live in the country, they won't be able to work, they will be subject to deportation, they'll be subject to all of those things as a direct result of this decision. That's a limitation of rights in anyone's language. It might be justified, but it's a limitation of rights. So that ground of review is also established. That leads me only to the last point, and the last point is remedy. My learned friend fairly says that he wants to consider our proposed draft order and reply to it. I would like to do two things, if I may. I would like to firstly just take you to the correct draft order that we've uploaded so that the court and my learned friends can see it. It is at 062-4. And perhaps I could ask the court to go there. Does the court have it?
Yes, thank you.
Thank you. The court will see, and I give the court the assurance that prayers 1 to 4 are exactly as they were in yesterday's draft order and in the notice of motion. The only change is prayer 5, which is a new prayer, and which says, in the event that the first respondent's further decision, so sorry, now my case lines is closed at the absolute critical moment. I apologize. If you would just give me one moment. Try again. Apologize for that. It's that in the event that the first respondent's further decision is to terminate the ZEP, such decision must allow for a period of at least 12 months from the date of the decision, during which the regime in prayer 4 will apply. When we formulated it, we realized that 12 to 18 was too unclear. So we have put in just 12 months, at least 12 months from the date of the decision, during which the regime in prayer 4 will apply. And we submit, for the reasons that I articulated yesterday in answer to the question from Mr. Justice Malindi and in my brief submission this morning, that would patently be an appropriate order. On the question of whether the court is entitled to grant it, even though it was not expressly sought in the notice of motion, could I give the court the relevant authority? The authority is EFF2. It's EFF2, which the court will find at 060-239, paragraph 211. The court need not go there, but I'll just read it to the court. There, the Constitutional Court held, the power to grant a just and equitable order is so wide and flexible that it allows courts to formulate an order that does not follow prayers in the notice of motion or some other pleading. This power enables courts to address the real dispute between the parties by requiring them to take steps aimed at making their conduct to be consistent with the Constitution. So what's clear there is that if this court considers that the new prayer 5 is just and equitable, it is empowered to grant it. Very lastly, on the question of remedy, we would say this: we have no difficulty with the proposition that our learned friend will file a short note on Friday. If there are new points in that, we might have to file a note in reply over the weekend, and we would reserve the right to do so, but we will try and avoid that unless it's necessary. But we would ask this: we again lay down the challenge that we laid down yesterday. Yesterday, I asked the following, because the court will recall that it's common cause between the parties that if you're with us on the merits, that you should grant prayers 1, 2, and 3. And the debate was prayer 4 and now prayer 5. And we lay down the challenge again. What do our learned friends say should happen on the 1st of July if prayers 1, 2, and 3 are granted and there is no prayer 4? What do they say should happen to these people? And I lay down that challenge again because it needs to be answered, because it has to be argued by our learned friends on behalf of their client on instructions that it would be just and equitable for this group of people to have no rights at all on the 1st of July simply because of the absence of a prayer 4. We submit there is no answer to that, and we wait to see what the answer is, but we will look forward to it. And if I may, we appreciate that there is urgency here. We've noted your indication that our learned friend must file their note by Friday. If we are to file a note in reply, we will make sure that it's filed by Sunday evening and uploaded onto case lines. My lady, members of the court, unless there's anything else, those are our submissions in reply.
Thank you, Mr. Butler. Judge Malindi, any questions? Mr.
My
Butler?
sister, only the fact that Mr. Butler corrects me and in my suggestion to Mr. Jamie, saying that consultation was necessary in view of the impact of the decision on the ZEP regime. Am I correct, Mr. Butler?
Yes, it's that exactly.
Thank you, my sister.
Okay, thank you. Judge Mota?
None.
Thank you, my lady.
Sorry, Judge Mota, do you have any questions? I didn't hear
No,
your
no.
response.
No, I said I don't
Okay.
have any.
Okay, thank you. Thank you, Mr. Butler.
Thank you, my lady. And I'm happy to say I only took half an hour, so I at least deserve a gold star.
Yeah, we'll see when we get to the end of this day. Thank you,
Thank you, my lady.
Mr. Butler. Mr. Simon?
Thank you, milady. And I too will try to be as quick as humanly possible. I realize I have been given the end of the innings, as it were, to finish matters. And I do not intend, therefore, to repeat the submissions made by HSF, with which we largely agree. We do agree with them that this matter, despite having been argued almost to death and with complexities and additions and variations arising, is at its heart quite simple. It is whether the termination of the ZEP, and termination in the broad sense, whether it is an effluxion of time or a decision, whether that termination can be reviewed either under PAJA or under the principle of rationality. And our submission and our answer to that is yes. Yes, it can, under both. Both PAJA and rationality apply, and I will be dealing with PAJA first and then with rationality on points which I hope are supplementary to Advocate Budlander's. But let me begin by taking a step back and saying, although Advocate Jamie SC did acknowledge that the principle of rationality and the requirements of that principle apply, there was nonetheless the suggestion throughout the argument, perhaps, that it doesn't, or that there should be no right to consultation awarded to these individuals, that they didn't have a right to be heard when the initial DZP was granted, or when it ended, or when the ZSP was granted, or when that ended, or when the ZEP came to an end, or indeed, well, they have some problems with the latest extension, lady, but I will get there. But the point is that the suggestion is that for years, almost 180,000 people have lived lawfully in South Africa with documents issued to them under specific statutory provisions that regulate and administrate their lives and their rights and their status in South Africa. And the suggestion or the theme is that at no point should they have had a right to be heard. And that, justice with respect, should strike the court as being wrong, and it is wrong. We emphasize it is a right to be heard. Let us not be sidetracked into suggesting that during the course of this lengthy period of time, we are talking about the right itself to permanent residence. Advocate Jamie emphasized that the courts will not want to say to government, we make policy decisions for you. We will tell you to grant Zimbabweans rights to stay in South Africa permanently. That is not the case, and that is not the issue. At the heart of this case is the basic right to be heard, not to an outcome, but that when decisions or exercises of law are made which have an impact on you, you should at least have a voice in that process. And as has already been heard, there are two defenses that have been raised by the government. The first being that there's some kind of, that this was a policy or an executive decision of some kind, and the second being a reflection of time. On the policy front, I agree with Advocate Budlander that one must bear in mind that administrative action is the translation of policy into effect. And the point I wish to emphasize is that at certain points of the respondent's argument, it is conveyed that one can tell when a decision is policy or not, because it furthers policy, and that in order to tell if it's administrative, you want to see as little policy there as possible. That, with respect, misunderstands matters. All administrative action furthers policy. It should. That's its purpose. That's what it's there for. That's what regulations and all of the administrative apparatus of the government exists to do, to implement these decisions. So when one says, is this decision furthering the decision to withdraw the ZEP or to expel foreigners, that is not conclusive in any sense of whether or not this is administrative action. And I wish to emphasize an example that I draw from Advocate Jamie SC's reference to Hoekstra. Hoekstra, and I forget his page, forgive me, and I won't try and take the court there for reasons of time, gave an example of a decision in the heartland of executive action. And that example was a decision to favor renewable energy over coal. Undoubtedly a policy decision, an executive decision. But when that decision is translated through the environmental statutes and it results in a decision to refuse a license or a benefit of some kind under the various acts that regulate coal, that regulate energy, that decision is classic administrative action that can be challenged under PAJA, and it is the same here. Yes, at some cabinet level or in the minister's mind, a broad policy decision was made. The court need not go there. The court here is seized with what the minister did when he exercised in terms his powers under section 31(2)(d), I think it was, to withdraw a particular benefit granted under the Immigration Act. That's what we're concerned with. Moving on, Justices, the second defense raised was the effluxion of time. And I think Advocate Badanda has dealt with this, and he's pointed out that this is not a complete answer, because in fact there was, that this was not a situation where the ZEP simply expired without anyone considering it. If one looks at the facts of this case, as evidenced by the documents placed on record, then despite all the fine nuances raised by the respondents in their various arguments, which unfortunately do not include an affidavit from the minister, it must be clear that this was not an automatic process. This was not something that just happened in the way that other visas, say, simply expire every day. Tourist visas expire. No one knows. No one thinks about them. This was a decision. The minister says it's a decision. Submissions are written to him by the Director General saying, I know you're thinking of making a decision. This is what I submit that you should consider. This is the decision I think you should make. The minister announces and publishes in the newspaper, I have made a decision, and these are the reasons why I have made my decision. And doubtless he does so because he recognizes, milady, that that decision impacted on a lot of people. And we have said this in terms, and there's no affidavit from the minister to suggest otherwise. We agree with Advocate Badanda that this decision may have been a negative one, in the sense that the minister may have decided not to extend. So the minister may not have exercised his powers to extend or to recreate, if that's a better word, the ZEP. But that changes nothing. Decisions can be of a negative nature. It's not only decisions where something's actually granted, but it's often perhaps even more so, where something is refused to a person, that questions of administrative action arise. Advocate Badanda referred you to the Grays Marine matter, and I think he referred you to that being upheld in an ESCOR matter. You've heard the court on that. I won't repeat those submissions, but he is correct wholly on those submissions. We would submit that this is indeed how the minister himself understood what he is doing, as you can see from the documents which he has provided. At a certain point in his address, Advocate Jamie said, and I apologize if I'm summarizing him crudely for want of time, but he questioned what would have happened if the ZEP had actually expired purely by effluxion of time. And he said that perhaps someone would have come to court then and complained about that. And we would submit that he is correct. So the point is, even if this ZEP had expired automatically, without a thought, without a decision, it would have expired, but that expiry does not excuse the respondents because it would have been unlawful. It's not what happened, because we emphasize again, there was a decision, both not to extend, and there is the current operative decision pending, which is extended for some transitional period, the matter. But if it did, there is no defense for the respondents, because to suggest that something as important as an administrative regime that protected 180,000 people, which was created to safeguard the asylum system and the immigration system from collapsing a decade ago, to suggest that that could simply expire automatically, without thought, without consideration by government, with respect, that would be irrational and itself unlawful. to turn to the latest extension, as we've submitted, we are challenging not just the non-extension of the ZEP, but the latest extension as well via amendments which were not opposed. And that by itself represents a difficulty for the respondents, because the suggestion, even if the ZEP and all of those previous matters have somehow, via the effluxion of time, become unimportant, and even if they were not challenged and limited by the pronouncements given at the time, this current one is live, and it is challenged, and it can be challenged. The suggestion made, as I understood it by Jamie SC, was that it can't be challenged because, firstly, it's a positive decision. It's not adverse. It's granting rights. And secondly, that if you, I hope I have his words right, if you accept a benefit or right, then you're bound by it, and you can't later on complain about some limitation or stipulation contained in that right. But both of those submissions with respect are, we would submit, incorrect. Firstly, this is an adverse decision. The fact that it extends the ZEP or the protection granted to ZEP holders for a short period of time does not change the fact that we're all aware that this is the termination, the ultimate bringing to end of the ZEP system, to the great prejudice of many, many people. Indeed, the minister has said himself that the extension which is granted is not because he wants to extend the ZEP. He does not believe it should be extended. He is granting an extension because he is ending it. The two decisions are interrelated. The decision to grant first 12 months and then a further 6 months is a transitional period in order to bring to an end, to terminate the ZEP. Secondly, if you are granted a decision and it is positive to some extent, but it contains a limitation or a negative aspect, you can still challenge it. If a person is granted whatever, a license of some kind or a permit or a right, but it is for some unknown reason limited to 3 months when it should have been 3 years, you can go to court and you can challenge that decision. You may not succeed depending on the facts, but it is administrative action and it is challengeable. And because it's administrative action, there should be a right to a hearing. There was a suggestion, Milady, that it's impossible to consult so many people, that the processes followed by the minister and the Director General in conducting this rational process were constrained by practical constraints. With respect, I should point out the minister did write letters to 178,000 people, and we have heard from Advocate Jamie SC that there intends to be some good faith consideration of those letters. But if it was difficult, I would submit that all the more importantly, then consult institutions such as CORMSA. If you can't talk to 178,000 people, which we will acknowledge may be difficult, then there are entities and persons and experts who can assist you in making the best possible decision because of what they know and because of their contact with that wider community and the rights and interests and desires of that community. That is why in cases such as the first Scalabrini decision, it was stated that Scalabrini in that case should be heard even under the principle of rationality. And we submit that that applies all the more so to CORMSA, which includes but is not limited to the Scalabrini Centre. Turning to the last question then, and that of rationality, because if all that I have said and Advocate Buttender has said about PAJA is nonetheless dismissed, then there's still a right to be heard under the principle of rationality. Justice Collis, I have lost your picture, but I see you're still online, and for reasons of time, I'm probably believe I should continue arguing.
No, sorry, I'm still there. I don't know.
Okay. All right. A few more minutes.
I can still hear you, and I was not aware that I'm on, that my camera is not on. I was not told also.
It's no issue, milady. Okay. The submissions and rationality the court has heard already. I'm not going to repeat them, but I wish to deal with one aspect of the argument made by the respondents. At various stages throughout the address by Advocate Jamie SC, it was submitted that the ultimate goal of the termination was rational. It was a policy decision to withdraw the ZEP, to expel or to terminate or get these Zimbabweans to leave the country. And that decision, well, it might be right or it might be wrong, but you know, there's a policy decision there, and that therefore is rational. And he took at the court to the ETV judgment, which quoted from the well-known dictum of the Democratic Alliance case concerning the nature of rationality. But even on this front, with respect, the respondents face fatal difficulties. The first is a logical one. It is that you cannot say that the purpose of the minister's decision was to withdraw the legitimate goal or purpose or policy outcome sought of the minister's decision was to withdraw the ZEP, because that begs the question. That's saying the reason I withdrew the ZEP is because I wanted to withdraw the ZEP. And if that's the case, then every possible decision would be deemed to be rational, because it would simply be the decision itself repeated. Rather, what you have to look to, as we will see courts doing in cases such as the Scalabrini decision and the ETV judgment, is saying, what is the actual outcome? You know, what is the purpose which you're trying to achieve? And you compare that sought goal with the step being taken, with the decision being made or the power being exercised, and you see if there is a disconnect. So if we look at this case, milady, what are the rational goals of the withdrawal of the ZEP? And the minister tells you, for example, in his various public statements, he says, for example, one of the goals is to reduce the pressure upon the asylum and immigration systems of South Africa, which you will not hear in the address of the respondents, and you will not see in the affidavits to any grand extent, because those are affidavits by the Director General again. But the minister says, these are the reasons why I did it. And once he said that, once we saw that was his goal, we can say, with respect, that is not rational. One does not remove what is effectively a cost-saving mechanism in order to alleviate the pressure upon the asylum system. That's irrational. A second goal that it was stated in the minister's reasoning, and I'm paraphrasing slightly, but it is there, the third point, is that he wished to have some kind of an impact upon the unemployment rate of South Africa. That is a stated and repeated reason given by the minister. But his decision will not do that. Once again, there's a disconnect, and it's irrational. Then lastly, it was the point about the 1,900 persons who had allegedly violated their conditions. There seemed to be, that was a reason given by the minister as to why he took this decision. But the decision he took has no rational connection to that difficulty, and one certainly cannot penalize the remaining approximately 177,000, my math is not good, persons who hold ZEPs because of anything that those 1,900 persons did. So with respect, Advocate Jamie's assessment of rationality, and in phrasing the rational goal to be achieved, we would submit is not correct. It is the submissions made by the Director General are perhaps what he sought to achieve, or would have sought to achieve, had he had the power and had he made the decision. But he didn't make the decision. He didn't announce the decision. He didn't give the reasons for the decision. And even if the minister were here today, the minister himself, as we pointed out in our heads, would be bound by the reasons he gave at the time, which are very clear. And unfortunately, for the minister and for the Department of the Respondents, those reasons are irrational. So we submit again that PAJA applies, and the usual rules concerning PAJA and the rights to grant a hearing, which the court has heard now countless times, that is where this court should decide this matter. But even if we are not successful on that front, then as has been accepted by the respondents, the principle of rationality applies. And on that front, the respondents fail. Those would be my submissions, my lady. I think I was 20 minutes.
Jumping.
Thank you, Mr. Simmons. Judge Malindi? Sorry, Mr. Motsweni?
No, we were saying that during when the parties were outlining the timeline for the exchange, it appears that everyone forgot that the truck driver still have an opportunity to reply.
No, we haven't forgotten about you. You are misguided. I'm pretty much aware that you have an opportunity to reply.
I'm glad we do, my lady. Would this then be an opportune time?
I've been sitting in this chair for some time, so I know that you have a right to reply. Judge Malindi, do you have any questions to Mr. Simmons?
Thank you, my sister. Mr. Simons, I don't know if I recapitulate Mr. Jamie properly, but he seems to have suggested that the directives issued were for purposes of setting out the implementation process for the holders of the permits to regularize their stay if they wish to stay in the country, or to relocate to their country properly if they so wished. The process that is laid out in the various annexures that he referred to, would those be adequate to meet the purpose of an orderly relocation or re-establishment of new status by the holders?
I think the court is referring me to directives 1 and 2 of 2021, which were essentially those regulating the 12-month and then the further 6-month extensions.
Yes,
Justice Malini, there are, let me be clear, there are aspects of that which are not, which we take no issue. One should, if one is going to terminate a matter, have some kind of transitional regime in place and so on. But they do not assist in justifying, firstly, the fundamental decision made, which is that the ZEP as a whole is no longer needed. They don't assist in granting a hearing to the persons affected. They are simply matters of bureaucratic streamlining. And thus, although they may or may not be in their own way positive steps, they do not assist, we would submit, in determining the legality of the extensions and the decisions at issue.
Thank you, Mr. Simmons. Thank you, my sister.
Thank you, Dr. Mota.
No, thanks. I have no questions.
Okay, thank you, Mr. Simmons.
Thank you, Justices.
Advocate Motweni, are you going to do the reply and not Advocate Mutapelo?
Yes, my lady, I will be handling the reply.
Right, then you may proceed.
My lady, we intend covering 2 topics in our reply. That is the preliminary point on delay, and then that is also the attack on the merits of the challenge. And we do so against the backdrop of what Mr. Rosenberg said. He spent almost 25 minutes addressing you why the application is incompetent on the basis for the want of condonation, alternatively based on unreasonable delay. What is important, my lady, is we need to first start look at what is the case that has been brought by the truck drivers before court, and what is the basis thereof. The case that has been brought by the truck drivers before court is not that the minister's decision was to be impugned on the basis of perjury. That has never been our case. Mr. Mujapelo, during the commencement of his address, made it plainly clear that at the heart of the truck driver's case is the principle of legality. Anyone with ears, including a deaf person, would have at least heard that is what the truck driver's case is premised on. So it therefore then goes to follow that, and that concession is also made by Mr. Jamie to say, well, we are not dealing with a perjury situation here. We are dealing with a principle of legality argument. And we accept Mr. Jamie is quite correct. that we are dealing with a legality issue here. With that, the argument by Mr. Rosenberg seeks to suggest that, well, that because of the delay, then the guillotine should fall on the truck driver's case. We submit that is an incorrect proposition. We know that this issue has been a subject matter before the Constitutional Court in at least 3 cases. That is Kumalo, Sita, as well as the other case. I forgot, is the Kijima case, as well as the municipality case, which the name just escaped my mind. What is important is that the Constitutional Court made it clear, and at this stage, we believe that the test should be tried that what the starting point is to look as to, one, there's that where the challenge is based on principle of legality, one need not bring a substantive application for condonation. However, that does not relieve the applicant of an obligation to at least come to court timelessly, if not, to at least prefer reasons why. And it is those reasons that inform the first leg of the determination, because this court must ask itself is the delay unreasonable? And that determination is done against the backdrop of the explanation proffered. Even if the second leg is, even if the delay is unsatisfactory, the court still has got a discretion, and we say discretion in a true sense, that to overlook the delay. Now, we have already, it is common cause that in these papers, although the ZEPs were implemented as far back as 2017, what is important is when was ATDFSA born? We know on the paper that ATDFSA was born in 2020, November 2020. And that was at least a year before the ZEPs could lapse, and before a year before the challenge. But what does what does the truck drivers say they did after the incorporation? The incorporation says they engaged government in order to address this very same issue, the problems which were created by the ZEPs. It is not that they simply sat and folded their arms and remained supine. They engaged government, and they continuously engaged government. It was then only when the negotiations were ongoing and no fruits were born, then the challenge that HSF brought the challenge. Then at that stage they then jumped on the bandwagon. So we submit that there is an explanation. One, because you could not have expected an unborn child to challenge a decision, which is what Mr. Rosenberg seeks to suggest. Say, look, ATDFSA ought to have challenged this decision earlier before its incorporation, and he relies on the letter by Messrs. Cohen, where they act on some freight and rail users association. That is but what he fails to point out is that the freight users have got no relation whatsoever with ATDFSA. They might be the visions and the objectives might be the same, but these are two different organizations, and the party that is before court is ATDFSA. But so we submit that there is at least on the papers an explanation for the delay, even if my lady and the members of the court are not with us on the explanation. We submit that you still have a discretion to overlook the delay, and that delay must, amongst others, take into account. In doing so, you must, over and above, take into account the nature of the decision that is being challenged here. This is a decision that's got far-reaching implications. This is a decision that is tainted with illegality, and we submit that the court would be abrogating its obligations if the decision was to be swept under on the basis of a mere technicality, which is what the courts have at all times warned us about. Say, look, you cannot, and that's what the Kumalo said, that you cannot allow procedural obstacles to prevent this court from looking from adjudicating matters of legality. And we submit that this is an appropriate case where this court ought to exercise its discretion and overlook the delay, if there is any delay. So we submit that any attack insofar as the delay is concerned is unfounded. We then come to the question of the merits, and I think it would be appropriate to preface our reply by first asking ourselves, what is the challenge? What is the nature of the challenge brought by the truck drivers? The truck drivers impugn the delay, the minister's decision, on the basis that the minister could not have lawfully issued or granted the exemption permits under the auspices of Section 3031(2)(b) for the want of the relevant jurisdictional requirements. That is one, that it must be granted to a foreigner as defined in the Act. Secondly, that it cannot be granted on the basis of nationality under the guise of a category. Third, that there were no special circumstances. And fourth, that the minister did not have the power to extend. Insofar as the first ground is concerned, the minister seeks to suggest to say, well, if you look at the definition of a foreigner vis-a-vis the definition of an illegal foreigner, the word foreigner encapsulates both illegal and lawful foreigner. But we submit that that interpretation is incorrect, because the drafters of the Act were quite specific, because when they defined a legal foreigner as a person who's in the country, who's neither a citizen nor a resident. And then they defined an illegal foreigner as a person who is in the country contrary to the provisions of the Immigration Act. And it is for that reason that in Section 31(2)(b), they were careful to use the word foreigner. And in doing so, it is clear that they intended that the applicant for that for the exemption permit must be someone who is lawful in the country. And we say that this is also buttressed by the fact that if one looks at the next section, that is Section 32. Section 32 makes it clear that an illegal foreigner must immediately leave the country unless he or she possesses an authorization by the minister. So now we know that from what the minister tells us, that that the main targets of these exemptions were the illegal Zimbabweans who were in the country, and those were illegal foreigners. So firstly, that makes them non-suited to be the candidates for these exemptions. And despite that, the minister went on and granted them the extension. So we submit that the interpretation that the minister seeks to argue in favor of the the word foreigner, we submit that is at odds with the very section itself. And we say this also, my lady, for the following reason. One needs to look at what is the purpose of the Immigration Act. The Immigration Act is not to regulate the affairs of foreigners already in the country. It is to regulate the affairs of the foreigners who wish to come into the country. In other words, this is a stopper at our border gates to ensure that all those who come into the country do so in accordance with the Act. Not that you must enter the country and then we come and regularize your affairs in the country. So now, if one was to say that, because now it would mean that the Section 31(2)(b) seeks to now regularize the illegality of illegal foreigners in the country, that defeats the purpose of the Act, because in its purpose, the Act is clear that it is to regularize entry into the country, not stay in not to regularize the illegal affairs of those in the country. Now, also turning to the question of the category, the minister wants to argue, say, well, Zimbabweans then become Zimbabweans can become a category. But we submit then that the minister used status as the basis for the grant, because if one looks at the added, is that by virtue of them being Zimbabweans and foreigners, that's the status. Now, you cannot use the fact that someone is a Zimbabwean, which is a status, as the ground for them to be granted exemption on those bases. So we submit that.
Sorry, what do you mean by status? You refer to nationality? Sorry,
nationality,
I don't follow your argument.
Yes,
nationality.
thank you. Nationality. Okay. You cannot use nationality because it would have because the Act itself also agrees. Look, it says a foreigner. It means that someone who's a foreign national. Now, why use nationality, which already the Act says it is foreign nationals who can apply for this permit? Why use nationality as the basis? You cannot use that to mean category. So the reliance on the nationality by the minister to say that nationality amounts to a category, that on itself also is at odds with the Act. We then comes to the question of the existence of whether there were special circumstances which existed. During our research and preparation, we went to great lengths to see if we could find any authority that seeks to suggest as to what would amount to special circumstances, and we could not find any. But the closest we could come to was that the word special circumstance can be equated to exceptional circumstances. And insofar as the authorities that we could find, exceptional circumstances is something that is out of the ordinary, of an unusual nature, and something which is, if accepted in its sense, as a general rule, does not, it's uncommon, rare, or different. Now, let us look at the reasons that were advanced by the minister insofar as the rationale behind the ZEPs. She advanced the economic status in the country, the need to maintain diplomatic relations between Zimbabwe and South Africa. We submit that none of those constitute exceptional circumstances or special circumstances. When we received, the minister had two opportunities. In this case, one, when we filed the intervention, two, when we filed the supplementary affidavit, to at least take us into his confidence by saying, look, these are the consideration or the factors that are considered constituting special circumstances. None whatsoever were advanced by the minister. We hear for the first time during argument that when I looked at the economic situation in Zimbabwe, but we submit that that does not constitute exceptional circumstances. Economic situations are a daily experience, especially in this day and age. There's an economic situation in Malawi, there's an economic situation everywhere in Africa. But then, so if that was to be used as a basis that amounts to special circumstances, why then not use it for other countries? There's a situation in Libya, there's a situation in Sudan. So it would mean that each and every person would then qualify for this exemption if one was to use the economic situation in every country, because neither country's got a proper economic stability. So we submit that equally the minister's reliance on the existence of special exceptional circumstances cannot be correct. Finally, coming to the question of the extension, in his answer to the supplementary affidavit, the minister said that he has got wide powers and he relied on regulations 25, 26, 27 of the Immigration Act issued in terms of the regulations. But none of those regulations have anything to do with the exemption permits. For the first time today, we are told that, well, the power to issue those regulations is akin to the power on me to set up conditions. But we submit that that cannot be correct. Because what we say this for the following reasons. We are not dealing with a private citizen here. We are dealing with an organ of state. And the difference between the two is the following, that a private citizen can do anything except that the law says he cannot do. Whereas on the other hand, government, which is an organ of state, can only do that the law allows it to do. So in the present case, there is nothing in the section which suggests that the minister has the power to extend. And we say this because the minister's own conduct demonstrates this appreciation and awareness, because when the DZPs expired, he did not extend them. He introduced a new regime. When the ZSPs expired, he understood that he had no power to extend. And what he did is he then went on to introduce the ZEPs. Mind you, why would, if the minister had the power, and we look at what he says in his papers, because the minister says, look, I wanted to at least alleviate the pressure on the immigration system. But now, if that's the case, why burden the immigration system by keep on saying, please reapply, when you could have simply extended? Because you could have simply issued one notification in the Gazette to say the DZPs are extended for 5 years. And then that would not require Zimbabweans to flock down the department's offices to apply for new dispensations. Because the reason why the minister did that is because he knew that he had no power to do so. So now for him to say, well, if one looks at section 31(2)(b), where it says that I can impose conditions, it also means that he can then it confers upon him the power. We submit that cannot be correct, because the power to impose conditions is not ancillary, is all related to the power to extend. So the reliance by the minister to say, well, I want to rely on the Masetla principle that the power to appoint also ancillary to the power to dismiss. That cannot be correct. It's like comparing apples and bananas here. So we submit that the minister's contention that he had the power to extend, we submit that is incorrect, and that interpretation by Mr. Rosenberg, it does not, in fact, find support for the extension. And then, therefore, we submit that for those reasons, we submit that none of the arguments raised by the minister together and as supported by both COMSA and HSF against ATDF, against the truck driver's case, have any merit. And also on those basis, the ATDF will still persist with its relief as sought in the notice of motion. Justice Collins, I do recall that yesterday you issued a challenge that we should upload a draft order. We have not had an opportunity to do so, but we'll do so between today and Friday. And so before then the court and other colleagues would have an opportunity to do so. Unless there are questions from the bench, those would be our submissions in reply.
Thank you, Advocate Motsweni. Judge Malindi?
No questions. Thank you, my sister.
Judge Morton?
No questions. Thank you, my sister.
Thank you, Advocate Motsweni.
Lady, may we, whilst the Master Mjabulu said I must pass the request that may we be excused from tomorrow onwards because we no longer have a role to participate in the upcoming 2 matters unless we want to come in as spectators.
Yeah, no, you will be excused.
Thank you,
Right.
madam.
All right, thank you. Well, I think we've come to the end of the hearing for the main application today. We will then await the note as indicated by Mr. Jamie. He would upload for the court to have regard to it. And then the draft, a response to the draft, if he so wishes to respond to the draft of the Helen Suzman Foundation that have now been uploaded. And then also a draft as indicated by Mr. Motsweni that they wish to upload. Can I just ask the parties, once you've done so, to also just direct an email to my registrar so that we can just be alerted that this has in fact taken place. So then, under the circumstances, the court will then reserve its judgment in the matter.
As the court pleases.
Thank you.
As the court pleases.
You are then all excused. Mr. Jamie, we'll probably see you tomorrow.
Probably, Justice.
Thank you.